Well, good evening and welcome to Friday, February 2nd, Groundhog Day. It's Groundhog's Day. I don't know why we still listen to a groundhog to tell us if we're getting spring or winter. It's just an unending confusion. DC area weather is really funky. Like we get hot, cold, snow, sun, everything. You can have an 80-degree day and then the next day, 15. It is exhausting. And it's also why everyone in the DC area is always sick, which is just wonderful and frustrating. Anyways, what are you guys doing? How you doing? How was your week? I want to hear from you. Tell me what you're doing. What have you been watching? What have you been watching throughout the week that's kept you occupied, preoccupied, otherwise occupied? I'm not sure what other occupied you can be, but what have you been doing? Good to hear from you. Good to see you. Glad to see all of you. Groundhogs had good news. Thanks, Mama Vets. First time catching you alive, says Darian. What a lovely night shift work commute. Well, I'm glad that you're here. Glad you kept alive. I love the live people that are here live, and I love the people that catch us on replay. I know that a lot of people view this on Saturdays and they go about the day doing their tasks, and I love that. It's amazing. The Crumbly Trial. It was a wild thing. And this one's interesting. I've been watching RA all week. And the Draconis trial. Interesting. Hey, I've gotten sucked into the Crumbly trial with RA. Interesting. It's really curious. Crumbley with RA, we've got there. A lot of you guys have been watching Crumbley with Recovery Addict. You know, Scott's a good friend of mine. And I tease him a little bit. And one of the favorite things I ever do is, well, I tease him with this particular video, which is one of my favorite.
Mary Murphy, member for 9 months, so they can't believe. Okay, stop. I need the Southern Febreze. Hey, can somebody bring me the Raid? There's a bug. There's a bug in my studio.
What in the world is that? Oh my gosh.
And I don't want to turn the camera on it because I'd have to zoom out so it would all fit in the camera lens. It just went behind the cabinet. You guys, oh my goodness.
There was this bug that had a huge, I think it's a roach, that had a huge thing of dust on it.
I will tell you what's going to happen. What's going to happen is this. That bug, and when I talk about bug, I'm talking, it's those, they call them water bugs here in the South. We know what they are, and they're not water bugs. That was like, it was the size of a small dog.
It looked like a monster coming towards me.
Holy cow. You unmute.
And occasionally when we get one of these that come inside from outside, usually when the fall down, they're around the leaves outside, but when they get into the house, I have words to say, and now it's literally crawling towards my green screen. So I'm going to be on camera like this, and then on the green screen, you're going to see a bug crawl across the wall.
I can.
This is bad, guys. It's going to be a bad day. I can't step on it because it was like at waist level on the wall, and my feet don't go that high.
There's a series of questions.
Oh, I just put my arm
based on what I heard Mr. Shapiro comment on about the 20.
Bug will be dead by the end of this show for sure. Bug has nowhere else to go. I mean, it's not like there are wires it can hide behind in here. Yes, cats will eat them. We're keeping the cat.
Is that voice menacing? Absolutely it is. It's pretty terrifying. It's terrible. I don't know what I did. I don't know why I did that. Scott will never live this down. Yeah. Scott's been, and then I got another one. Scott's been keeping us entertained. Well, that is remarkably fortuitous for us this evening because joining us is the man himself.
A day that will live in infamy, Rob.
Infamy.
Bug day.
Infamy indeed.
That was fun. I have to say first, before we mock me with the bug any further, congratulations on 203,000 subscribers.
Thank you, sir.
Awesome.
Thank you very much.
Thank you in person.
Well, I have loved watching the growth of your channel, and it is so fun to just see the effort that you've put in, both in the remarkable setup that you have, which is one of the coolest things I've ever seen, and I'm very jealous of it, and two, the buttery voice, which is remarkable. Now, I know that you're going to say that you put enhancers on it, but that's bullshit.
Yeah.
It's just
You meet me in person, you're like, who's this whiny guy? Who's this whiny guy
come
with the high
on.
voice?
You know, I get the comparison I get the most that I shared. We had a firm-wide happy hour yesterday, and the comparison, I finally voiced it. People compare me the voice to John Cusack and the mannerisms and the tone. And I said it out loud yesterday at the partners only, or not partners only, the firm-wide happy hour. And all of a sudden everyone just goes, "Oh my God, I can't unhear that." I was like, "Oh,
Now forevermore you'll be known as a stunt voice double for him.
He who sounds like John Cusack. There are worse voices to have.
It
And worse
could have been
people
worse. You could have had like a bug incident that was caught on camera that
Oh, yeah, on a live stream.
all
that
your friends
you
would
know,
play over and
that
over.
someone would go back and take the entire live stream and clip out the little tiny baby segments and do a bunch of jump cuts and make it a fun little adventure. And then another friend of mine has another incident within the same trial. And yeah, the number of I don't know if you've gotten them, the fake cockroaches.
I got a box like full, just like huge bag full of them. We gave them away on Halloween.
Someone sent me a 3D printed massive cockroach that has your name inscribed on the front of it. Please tell me you have it. Yes, you do.
Yep, he sent me one too. Said it was you had a replica as well.
Oh, that is so awesome.
It's got the date
so
and everything.
awesome.
So it's pretty cool.
Well, we cover a lot of trials, and we cover a lot of things that are very difficult to talk about. So you kind of have to find a way to make light of some of the situation, because you can't. If I'll tell you too much, if you take this stuff 100% of it, 100% of the time, as seriously as honestly it deserves, it weighs on you a lot.
Crush you. Yeah,
it can really crush you.
It's heavy.
And I talk about that with the family law coverage. Like, I'm a family law practitioner. Hi, guys. For those of you new to the chat, hi, I'm Rob. That's me. This is Scott. Scott has a channel, lovely channel, Recovery Addict, where he does a bunch of trial watching, loves the trial watching. And he likes to say he's not a lawyer, but he probably has a pretty freaking good foundation on the law. And it's really impressive. I love how he manages his chat.
A mile wide, an inch deep. That's my knowledge base. That's what I've got. So I depend heavily on you.
You ever heard of the phrase "Jack of all trades, master of none"?
I've heard "Jack of no trades, master of none" referred to me, but
well, "Jack of all trades, master of none." Now, did you know that that's not the end of that phrase?
What's the rest?
It's "Jack of all trades, master of none, but oftentimes better than a master of one."
That part gets left off a lot.
It gets left off every single time, but I love that adage. I think it's one of the coolest things that we never ever say, is the compliment of the people who really do try to become a master of all, who try to take in new things, learn new things, experience new things. And you do that with your channel. And I just love watching it. It's fun. Not to mention your intro video is awesome.
It's fun. I need to update that one. I did just take the dive tech-wise into new gear. I picked up some of these fun cameras that we see in court, the pan tilt zoom, that have like a zillion connections.
That I can set you back a bit. My gosh.
About three big ones, but I can plug this in California and control it from my house. It's just it's amazing, and I get the feedback as well. So it's cool. So we're slowly building our court watching, because there will be a day when my channel, or my business side, the Top Market Media side, is going to be the pool media and some court cases. That's what we're working towards.
I just realized something. You said you're building the court watching, but you're also doing I'm doing some beard watching. And the last time that I spoke with you, that thing was gone. What are you eating and ingesting?
I think it's the comb that's doing it. My son bought me this beard comb for Christmas, and I've been using it religiously. And this, I shaved yesterday, so this is all fresh growth.
I'm sure.
I'm jealous. I'm jealous of Ian's hair. I'm jealous of Peter's hair. I can't grow the top like that, and so I have to try to compete on the beard. But it all comes in white for some reason.
Well, there's worse things. Where was it? I was going to catch a couple of these things. Boys love toys. They do. The beard comb is definitely a toy. I'm sure that he enjoys quite a bit. Yeah, there you go. Oh my God, RA and Rob. Woot. Yep. Having some fun. We're gonna talk about some sensitive topics, but we're gonna answer some questions. We're gonna go through a lot of this. I've got 3 topics tonight that I wanted to cover. 3 particular topics, but before I do that, I would be remiss if I didn't do something, and I've got to do it ASAP. So my paralegal is a wonderful, amazing person who is a rock star. And I don't get to shout her praises enough, but it is now Girl Scout cookie season. It is Girl Scout cookie season. It is the season of the Girl Scout cookies. And I am pinning a comment to the top because I would love to make that just go bonkers. So if you guys see the pinned chat, if you guys are looking for Girl Scout cookies, that pinned link should bring you to the part that says you can have them shipped to you. They're phenomenal. So if you wouldn't mind, that'd be great. Because I would love, one of the coolest things is walking back in on Monday. One, I don't think she ever watches. If she does, hi, Gwen. Glad to see you here. But I actually think a lot of my law firm is now maybe watching. So I'm sorry. Very sorry. But not. But yeah, what would be really cool on Monday if she came in just with this big old shocked face. Like if you just took that goal for the Girl Scout cookies and blew it out of the water, it'd be great. So that's pinned for the moment.
I'm shopping right now for cookies, Rob. You have to give me a minute.
Oh, that's fine. I know that they're regional too. You can only get they break them up. There's certain special cookies that they have by region, and they're phenomenal.
I fell in love with the lemon ups last year. I had never had them before. I realized some people try all the cookies. For some reason, I just find one I like and I stick with it. But the lemon ups, someone had me brought some over, and it's like, oh my goodness, where have these been all my life? They're delicious.
No, they're amazing. All of them are amazing. My problem is I have too many friends with too many kids, so I've just started donating. It's like, here's $50, here's $50, here's $50, here's $50. Like, just because I can't do all the cookies. I would be 400 pounds easily, because they would not survive very long in my household. So chat's flying already, so I got to catch up on some of these super chats. And I think some of them have to do with the individual on screen. Let's see. Cross Stitch 626 says, is it bad that I planned my birthday dinner to end in time for me to attend FNF? Yes, that's bad. Don't move your schedules around. You can catch replay, guys. It's not impossible. You're allowed to catch a replay. Happy birthday. Happy birthday. I hope you have a wonderful birthday. Here's to the next year around the sun, and may you make it the best year yet. Every birthday, every year should be the next best year in your life. Yep. It's amazing. Red Pen. Oh my God, it's RA and Rob. I love this. Aaron Patterson, 2 of my favorites. Thank you. Vez is saying, I'm late, but I made it. Hi, guys. Hi, Vez. Got gift fairies in the chat. Canonical Heat gifting 20 memberships already early on the stream. Thank you very much. Dawn Burke is asking about the Delphi case. I will start diving into that. It's going to take me some time. There's a whole lot going on in that case. And that's one where I definitely need to know a lot more about the case in order to talk about it. Jessica Hicks, not going to lie on this case, in my not guilty on this case, in my opinion. Congrats on the new puppy. This case, I think the Crumbley case in particular, is going to have a lot of people feeling very conflicted. The law is remarkably complex. Berta S, love this duo. Thank you very much. That's very kind of you. Canonical Heat, appreciate the mods. Poke the like and subscribe buttons. Notifications are nice too. Yes, I want to do a massive shout out to my mods. The mods are what keep the chats in a form that allows the video to remain up on YouTube. People don't realize this. YouTube videos and channels have been taken down for what chat is saying. So if you see people in the chat, or if you see the mods, one, tell them you appreciate the job they do. They volunteer this time. And one of my mods, actually, Sandy, is behind the scenes tonight because Mischief is not feeling well. So they go above and beyond, and they do so much to keep the chat online or on task and on topic, because it's tough, especially with some of the stuff that we cover. So mods, you guys are amazing. We love all of you. Julie, my boyfriend, says that with all the trials I'll watch, I'll be a lawyer soon. LOL. Said I can't even read all the way through the terms and conditions. You know, there's a funny secret. Lawyers don't read through the terms and conditions on most contracts because they're contracts of adhesion, which means you don't really have a choice to modify those terms and conditions, but you try. Show RA some Jeanette Braun as a palate cleanser. No, it's not a palate cleanser. That's a torture device. I can't. Have you been watching any of the Jeanette Braun stuff that Ian's been covering? Oh, you're muted. I don't know why.
Oh, sorry. I've had lots of funny commentary all through this. I apologize. But it was just on myself. I muted myself. I have not been following Ian's. I've been following him on Twitter as he's trying to regain his full health, and coming back from Las Vegas. I think he caught a bug down there or something. But I haven't followed that case.
Oh yeah. Well, Ian on Twitter. If you guys are on Twitter, if you decide to jump into that cesspool, which I always recommend, if you don't have the stomach for it, don't do it. But if you're on there, Ian is definitely 1000% worth the follow. Literally one of the funniest people on Twitter. His way with words is truly just freaking hysterical. But he's been battling quite a bit of sickness recently. So I don't know if he's going to be able to join tonight because, like I said, he ain't feeling too well. I'll send him a note here in a minute just to see how he's doing. Timeout. In the hospital waiting for my daughter to be born. Congratulations. Spending some time watching the frenzy that I don't normally watch. Glad to have you here. Relevant question now. When is seven lawyers going to be too many? Could the judge say it enough? Last one.
Just talking about Sarah Boone.
We're going to get to that. And I don't know. The first three were conflicts. So that doesn't really go towards her, the allegation that she's starting to forfeit her right to counsel or that she's starting to waive it by her own actions. But the last four have been, well, when your client is writing stuff to the court saying how you're unethical, not doing your stuff, not doing everything, it can create tension in the room. And when your client is trying to use your legal prowess to advance a position that doesn't have support in the law, you run into problems. So, yeah. But we'll talk about that when we talk about Sarah Boone. Let's see. We've got great seeing you two together from Karen Dietrich. Thank you. Valerie, cheers to Ari's closing statement. Call out. What was the closing statement call out?
The defense attorney, Shannon Smith, said, apparently I've got people on, she said, TikTok who are keeping track of how many times I say sorry.
Oh no!
During the trial, and we had a sorry not sorry counter running throughout the entire trial because at the beginning of the trial, and I wasn't doing it to mock her. And now, honestly, Rob, I feel bad about this because my wife came to me. She said, Scott, you're bullying her. I'm like, that was not my intent, right? It wasn't intentional. If I can steal from Sarah Boone, but I was. She has this, a way that she uses this word a lot, and a lot of times she uses the word sorry in a sentence that she's not really sorry. And so we made a sorry, not sorry counter. And we ended up counting every time she says, I apologize, or I'm sorry, or some variation of that. And we're up to 248 times.
248 times. At that point in time, it's just one of those ticks.
It was just, we thought it was a funny thing, but she apparently saw it. She said it was TikTok, but there's no counter on TikTok. It's over here on YouTube.
It's here on YouTube.
I think I'm actually going to call her and say, look, I'm sorry. I didn't mean to be rude because honestly, that's something I don't want to be the bully. Right.
Now,
but I want to invite her on the show
when
and
you say
look,
you're sorry. Because you don't want to say sorry, not sorry.
I was gonna say, are you gonna tell me never apologize to a lawyer, or what? Is there some sage advice there?
Just tell you how maybe when you say I'm sorry, maybe express it in a different choice of words, like my apologies, sir.
Could you write my apology letter, and I could just sign it and send it to her with that? How much you charge?
I'll do it for free for you.
Okay.
Happily.
Yeah, but she called us out a little bit in the closing statement. She was Sort of, it was a weird closing statement. I don't know if you want to get into it right now, but because it's really the end of the trial.
Oh, please.
Okay. It was a very strange closing statement, and I saw a bunch of people, from Latu on Twitter, just like, what is going on here? What is happening? Why is she sinking her client's ship? But she had this strategy where she put herself into the spotlight, really, and injected her story and her family, her parenting style into the closing statement. And she's just spilling the beans about how long she hasn't washed dishes, or how long she hasn't folded clothes and doesn't clean the room, haven't taken down their Christmas lights, how she hates
about
going
herself.
But I think what she was doing was trying to say, jury, I'm just like you. And then so she talked about herself like this, about how she's an awful mom, and she was swearing at her husband on the chat, the text string last night, and that's just life. And she says, I could be in Jennifer's position. We're exactly the same. That doesn't make me a bad parent. Well, she went on for so long. I'm like, so people were like, well, that the one thing you mentioned there, that's a little much. Saying I'd rather be anywhere but with my kids. She started losing some people, I think, there. But I think she was trying to connect with, I believe there are more women on the jury than men. And I think she's trying to connect with those women in case, lots of moms, and I saw it in my chat, lots of people said, hey, she gets it. She's, that's a mom. I've been there. It's not the highlight. It's not the Instagram version of mom that we like to think about we all are as parents. But she's like, we get it. And a lot of people, I think, in that closing statement, liked her more than the rest of the trial.
Oh, well, I'm being told two things. One, Rob buying cookies online, requesting a code for the girl to get the credit. Did you have one of for your paralegal's daughter? The link should give her credit immediately, and I pinned a new one that's a different one I have from her, so that should give her credit automatically. Cookie goal is at 135%. Law Nerds rock. Y'all do absolutely rock. Ian Paler been to Vegas twice, and I've returned sick. It is a lot. Ian has shot shoe flu. Most come back with it. Speaking of Ian had some opinions on the close. Marble the Cat is saying 129% for that. Ian's opinions on the close, he adequately expresses in his Twitter. Well, not adequately. We'll just say he does. Did she really reference the TikTok stuff in the closing argument? You're muted, my friend. You keep doing that to yourself.
I'm going to stop doing this. Do you know who Tyo Toys is on TikTok? TYO
No.
Toys. His name is Phil, and he makes little cuts. He's probably going to snip this. He cuts little bits out of all of the LawTube streams. And so he gets little bits that he's really quick. And he's already taken that little clip. So if you go to Tyo Toys as his Instagram or his Twitter feed, he posted a little stream that's just her saying that, and then it pans down to my feed where it's got the sorry not sorry counter in the bottom. But yeah, it was real. It was a thing.
Well, Ian had opinions. Yeah. Why the F did Crumbley defense lawyer just tell the jury that people are making fun of her on TikTok, and why is she going to rant about how unlikable Crumbley is? And then apparently she says, I have an oopsie baby?
Or two. I think she said she had two oopsie babies.
Ian going on, should I be accountable for sending child? Oh my gosh.
Oh, she didn't stop there. She went into detail about what would be in the picture. And she's like doing the hand motions of like holding the camera down by the waist level. And if my son takes a picture of his, and there was nothing, she didn't hold back at all. She just laid it out on the table. It was an interesting choice.
Well, that's a choice. Clearly your cachet. Oh, and I'm so grateful to the internet for telling me that I don't know how to pronounce cachet. What the hell?
So cachet, there's a part in the trial where Jennifer sent a text to her romantic love interest saying, clear your cache. And the prosecution extracted that text and said, this is them saying, delete all the messages. Well, if you zoom out and see what happens around it, she's saying, clear your cache and see if my Facebook account goes away, because she was trying to delete it, take it down after everything, so she wouldn't get all the hate mail and stuff she was getting. So she's saying, clear your cache and then check. And he's like, oh yeah, now it's gone. Cache in that sense is spelled C-A-C-H-E. And this lawyer pronounces it cachet. And then she She's like, clear your cache. Oh, and thanks for everybody who told me how to pronounce it. Yes, I know how to say cache. I'm like, no, it's still cache.
And then Ian, it's still cache. Ian makes a great point. The jury's not supposed to have been following the case repeatedly. Telling them that the internet is mocking you is a great way to prejudice them against you and your client. I have been... This trial has frustrated me for several reasons. Several reasons. One, the subject matter sucks. Terrible, terrible subject matter. Two, I do not understand this courtroom. Like, I don't understand the judge. I don't understand the attorneys. I don't understand this. It seems like it's a bickering match between children, and I don't get it. And it frustrates the hell out of me to watch it because it's also what's going on. Well, you know what? I'm gonna do this. Let's go to one of the exchanges. Let's see if I've got the appropriate time queued up. I probably don't. Let me see. See here, the cross-examination. It happens pretty early on in the cross-examination. So we'll go into the cross. We'll start with the cross of, and here's the thing, Jennifer Crumbley. Common advice is not to allow your client to take the stand or to advise them very strongly against taking the stand. But in this particular case, I think that you kind of have to. I can see how you're kind of boxed in because the question is whether her conduct in supervising or in raising her child or in the absence thereof created a risk that she should have been aware of. And it was a reckless disregard of that risk that led to the school shooting. Very strange case, and one that makes lawyers remarkably uncomfortable because generally speaking, the general rule is the voluntary act of someone else is their own actions. It cannot be attributed to another person. Think about this in the context of a 16-year-old with a learner's permit, right? 16-year-old learner permit, they're out driving on the road and they get into a collision. And I don't know if you use this example or other people. This is the example that most lawyers will use to explain this stuff. When a child goes out and drives at the age of 16, they are tasked with a certain amount of responsibility, their own accountability for their own actions. I mean, this begins very early on in our lives, even younger than that age. It begins, with your children starting to tell lies to you, or when they get in fights at school, right? Everything that child does doesn't automatically come back to the parents who raised the child. So if a 16-year-old is out on the road and gets in an accident, that's that person's responsibility. It doesn't automatically go back to the parent. You have to find some pretty egregious things in order to tie that back to the parent. And the other way we talk about this is in dram shop laws about the service of alcohol. And where someone goes to a bar and lawfully consumes alcohol, when they leave the bar having consumed alcohol, if they get in their car and drive home, that's their voluntary choice. It's very difficult to get to the threshold where you can hold the establishment accountable for the actions done voluntarily by the other person. It's a high threshold. And when you talk about the willful act that is this willful, that is this level of conduct, it becomes in the law a very high burden to overcome. And it makes you uncomfortable when you even think about prosecuting someone for this. Now, this case, I will say, they've got a whole lot that was there. And I think the question comes down to credibility. It really does in this one. Do you find Jennifer Crumbley credible or not? So the other thing is, this jury is sitting there. Well, you know what? Let's get into it because I've got this one queued up. Rather, I've got the beginning of cross queued up, and the lawyer for the prosecution comes in hot, and it was pretty I want to say shocking. First of all, it is every prosecutor's dream to cross-examine a defendant. It is the dream of the prosecutor to cross-examine the defendant because the defendant is, you have all this information, and what you really want to do is put words in their mouth and say, you said this, you didn't say this. It was remarkable. And the lawyer here does a pretty good job. I will say he kind of starts in an area that makes me confused, but let's just play the beginning of this and see. Let me see if we've got closed captioning. Oh, we do. Look at that. Awesome. No, I don't want to. No. Okay, let's see. Let's start with that. And Scott, if I disappear on screen, it's just because I have to grab something real quick.
Yep.
Thank you. This is Crumbley. I'd like to talk.
How's the volume? Should I boost it?
It's pretty good on my end. I've got headphones on. A tiny bit up might not hurt though.
I'm going to try it. We'll be 300%. Hang on. I've got to exit the full screen so they can apply.
Talk to you about your vigilance as a parent. But before I do, I want to make sure that you understood the oath that you just took.
I do.
Okay, you understand that you took the stand under oath and you have to tell the truth.
I do.
You understand that was the rules yesterday as well.
Correct.
All right, we're going to come back to that.
Right off the bat, he starts with an area that's pretty iffy. You can't start suggesting that the person is going to lie. So the question's about, you understand that you took the oath to tell the truth, and you understand that you swore to tell the truth, and you swore to tell the truth yesterday. Usually you don't get to start doing that because the implication is by those very questions that the person was lying and is lying. And you have to kind of wait until that person sets themselves up to say, are you aware you're under oath? Because it's pretty audacious to basically just go in there and say, by the way, you're under oath immediately, because the suggestion is you're lying under oath. So prosecutors start swinging for the fences immediately.
Now, you have been described by your attorney as a hyper-vigilant parent.
Correct.
Okay, do you agree with that?
I do.
In fact, you called yourself a helicopter parent before.
Yes, I was.
So you told us you spent a lot of family time together.
We did.
Now, I'd like to talk to you about what your digital footprint shows,
Okay.
what the evidence on your phone shows.
Okay.
Now, it's true, you agree with me that having horses is a pretty time-consuming hobby,
It can be.
okay? It was for you,
It can be.
and that's what you said yesterday,
Yes.
okay? And you were at the barn for between 3 and 5 times a week?
More like 3 times a week.
3 times a week
Yeah.
for a couple hours a trip?
Correct.
Okay. It's also an expensive hobby.
It is.
So your banking records show that in the year of 2021, you spent over $20,000 on the horses. Is that correct?
Probably.
Okay. And that's not including cash. That's just from Capital One and Flagstar Bank.
Correct.
In fact, you told a coworker that half of your salary basically goes to the horses.
I might have. Yes.
Now, except on rare occasion, you didn't bring your son with you to the barn.
He was not into horses. I would ask every time I went to the barn, but he didn't want to go.
So the answer was
All right. So right off the bat, he starts going financials. Weird take for me. I didn't understand where he was going with the financials. How expensive it was.
This is strange because they're trying to show that she is a negligent parent, and the reason why the financials became important is because they also showed that her son did not have health insurance coverage at the time, but she did. And so the way they're spinning the story is you've got money for the horses, but you don't have money or
insurance,
and you've got time for the horses, but you don't have money or time for your son. That was the whole big picture they were trying to show. And I think they went with the horses because there's odds are most of the jurors don't have horses. I'm just going to toss a coin out there. Most people don't own horses, right? If we're in Wyoming or something, it might be different. But so I think a lot of people are like, wow, that's a lot of money to spend on a horse. And that is weird and different. And why wouldn't you spend it on your son? When the defense gets a chance to counter this argument, they put a good spin on it and sort of zoom out and get a bigger picture. And it helps a little bit because he did have coverage under his dad's plan. His dad lost his job, was now doing DoorDash, and Jennifer Crumbley was going to, add him on during open enrollment. I think if you have, like, I'm not sure if the job loss is a life change where she would have qualified to add him immediately. I'm not sure about the rules in Michigan, but that was how defense spun this one.
Okay. I just thought it was, if you're going to start, I guess, so the prosecutor he definitely has a style. Swing, slow, swing, slow. So big, not big, big, not big. He goes up and down. Now he does move chronologically, which is unique for prosecutors. They will usually try to jump around in the timeline to get people caught up. He goes chronologically, but you can tell when he goes chronologically, he goes big moment, little moment, big moment, little moment. And the horses was one thing. So the other thing that I took from this is her responses. She is real quick to respond. Okay. Okay. Yeah. Okay. Yes. No. Good and bad. It depends on how the jury has perceived her during the trial. I tell clients when they're being cross-examined that you try to answer the heart of the question, the actual question that's being asked, in as few words as possible. And that's it. The okay is when he's signposting and saying, I'm going here next. And she goes, okay, okay, okay. That demonstrates a little bit of eagerness to get to it. So it's kind of a tough thing to hear. It felt a little off from the beginning.
It was her answers on direct were also a little bit quick, not this fast, and it didn't have that snap to them that the cross examination answers did, but they weren't that, it wasn't that big of a jump from how she had testified before.
Yeah, and this is not sped up, folks. This is real time, not sped up. So the answers are coming, and they might seem quick, but that's real time.
Was no.
No.
Okay. And at least as far as your horses being boarded with Kira Pennick from June of 2021 to November of 2021, your son never went with you. Is that correct?
I think he went once when my in-laws were in town and we met them at the barn.
Okay. But there was nothing stopping you from taking him.
No, he just didn't want to go.
Okay. It's a family atmosphere.
It can be.
Okay. Like the Halloween party that she had, that was for families.
Yeah, most of the kids there are young.
Okay. In the winters, you were on ski patrol as well.
Correct.
Okay. And that can be a bit of a time-consuming hobby.
It can be.
All right. And you would be on ski patrol between 1 and 2 times a week?
It's a total of 10 hours a week.
10 hours a week. Okay. So how many days?
I did doubles on Saturdays, so 1 day a week for me.
Okay. So you told this jury yesterday, you depicted your affair with Mr. Malash as a 1 time a week meetup at a Costco parking lot. Is that your testimony?
Correct.
Okay. But it wasn't just that, was it?
Nope.
Okay. In fact, there are numerous photographs sent to Mr. Malash.
Okay.
Yes or no?
I'm sure there was.
Okay. Numerous messages exchanged with him.
Correct.
And it wasn't just during the week, Monday through Friday, was it?
No.
No. In fact, that's what you said yesterday. But in fact, it included trips.
There were actual business trips that he met me on.
Okay. And it included other individuals.
Yes.
What's Adult Friend Finder?
I mean, at least it wasn't FetLife. Come on, how many times have you seen FetLife come up in a file?
Well, more than you would want, more than normal people should. Correct me if I'm wrong, but the defense won a motion in limine to exclude any information about the affair.
And then they brought it back in.
They kicked the door open willingly.
Defense lawyer did not properly prep their witness, because their witness ended up kicking open several doors they should never have touched and answering several questions in ways that showed zero prep.
Now, this is a bit of a dirty move by the prosecutor. Like, I don't like it. I don't like hearing.
I mean, the prosecutor's gross.
But he doesn't just go for the affair. He's bringing in Adult Friend Finder. He's bringing in not just the affair, itself that she opened the door to. But now she's bringing in third parties and other people. And he is trying to depict her as being of a certain lifestyle that now I can see a tangential argument that one would say, if you're trying to manage all of this, you're not, several people, this other stuff, you're not adequately supervising your son. But how do you get into this adult friend finder thing? That was,
I mean, once the affair is open, how does the affair happen seems to be open.
The judge tried to sort of put blinders on this and sort of couch it just to this relationship. And there was sort of when they first kicked the door open, the judge sort of said, "I'm going to let you go here, but I'm not sure how far I'll let you protrude." And we knew they were going to push as far as they wanted to, but it was eye opening.
at the beginning, when the defense attorney let that door swing open, I was going, this has to be strategy. There's no way that this was accidentally done, right?
Really? Do you see this defense lawyer and you go, man, this is a strategic genius right here?
I don't know.
No, the answer is no, you don't. This defense lawyer is not a strategic genius. They have moments where they do great, and she has moments where I'm just like yelling at my screen.
Well, that's the part that drove me nuts. Was there's points in time when she makes a great argument, and I'm like, that's a solid argument. And then the next minute, within 60 seconds of that argument, she's doing something. I'm going, what are you doing?
Oh, I mean, a lot of the time her actions have just been like she'll do a perfectly like competent cross-examination, and I'm going, that's great. Or she'll, even in her clothes, there were moments where I was like, yes, absolutely, that is the thing. And there were moments where I was like, oh my god, you did not.
For those of you
Like,
that are just listening, Ian's mouth just shot open. He's like,
she drew a comparison to child porn.
well, you don't have to say it out loud on the stream, buddy.
Well,
we were dancing around that topic. We weren't going to hit it directly.
Fair. Okay. She drew a comparison that you should never draw, which everyone just heard. So I'm not going to repeat it. But, and the thing is, you know, some people said, oh, that plays, you know, that was just fine with me because I've got a kid and I can imagine it. Well, you could also imagine your kid borrowing your car late at night and getting into an accident.
Yes.
And that doesn't have the same connotation.
Getting into a fight at school, or, you know, finding alcohol and drinking it. Like you can
yeah,
take a hypo.
The kid takes a kitchen knife. I mean, the kitchen knife thing was just fine. The kid takes a kitchen knife to school, gets into a fight and stabs somebody. How did you not notice the kitchen knife was missing? Like this kind of thing. The problem is that when you get into, you know, cheese pizza, that is sort of a berserk button for a lot of people. And it just shuts off their rationality. And if you tell the jury, hey, at some point, if you agree with us, somebody might not be convicted on a cheese pizza file, even if it's a person who's like factually innocent, you might have one juror who's just like, now I'm going to convict. Now I'm going to convict no matter what. And you could flip that person from like, I was totally on your side to I'm a convict, I'm a convict, I'm a convict, and cannot be talked out of it just based on that. Like, I think, and the parts where she's doing great on clothes are because she has better evidence. Like, it's easier for her to make the case because I think the defense side has better evidence. The prosecution at times was losing me because I'm watching them and I'm just like, okay, like you just called this witness to testify that he was the counselor and he didn't decide that this was an emergency. So how's mom supposed to do this, right?
Mm-hmm.
I'm going,
and that's where I would have focused. I would have focused on that school interview.
Expert after expert after expert sees this child. None of them raise the alarm. They don't tell her that it's an emergency. How is mom, who's just a mom, supposed to know this? She is trying her best with a difficult kid, but she has no conception in her head that this kind of tragedy could ever happen because whoever could think that of their child? Whoever would think that of their child? This is such a rare event. This officer who testified that he's seen all these victims has never dealt with something like this. Mom has obviously never dealt with something like this. When all of the experts miss it, mom has to spot it or else go to jail?
And that's
Are you,
well,
what is
that's-
every parent of a disturbed child, every parent of a child with depression, with autism, with attention deficit, with social difficulties, with any of these issues,
bipolar, with any type B personality disorder, with any of those things? Yes.
do they all, they may be dealing with a child that they don't understand. Do they always have to assume the worst or they might have to go to jail? Can they not try to reach their child with hobbies that the child seems to enjoy? They're trying their best. And sure, they go and they ride horses.
She could have made that argument. She could have.
Yeah, but you don't compare your client's acquittal to acquitting somebody on cheese pizza. You just don't do it. The other thing that baffled me.
Interject. Oh. Scott was going to say something.
Sorry.
The argument I'm going to play devil's advocate here. The argument the defense is going to put towards this is that the prosecution is, and I'm going to lost on here. The prosecution is saying that, or defense is the prosecution says she missed all these signs, right? She's negligent. She missed the signs. He said, help me. I see demons that are throwing clothes off the shelves and bowls are flying off the shelves in the kitchen. I want help. My parents won't listen to me. Please, and they're saying they missed all the signs. The defense is going to say to back it up. And all those comments in context have a different explanation. And so you can, one by one, you can pick them off and say, that really wasn't a sign. By itself, that one wasn't a sign. Yeah, I think altogether, there would be somebody to say, hey, my kid's probably going through something. But I agree. You're not going to just have to anticipate that my kid's going to do the worst thing imaginable because we had a disagreement last night.
How many of us have been in a bad relationship in the past? Show of hands, probably everybody's got to put up like both hands and then borrow a few from the local cemetery because, it just, and how many of us have gotten to the point where you're like, okay, I've broken up with this, and your friends are all like, thank God, because they saw all the red flags
and you didn't
long ago, and you didn't. That's happened to all of us, right? And who is most like close to somebody in a way that you might miss red flags? Oh, right, the parent. That's where on the law I have a difficulty with this case. But I didn't want to focus on the cases. Let's play a few more minutes because we're about 3 minutes away from a little exchange that gives us an example of how the lawyers have been litigating this throughout the trial.
Where you can go on and meet people who meet certain tastes that you're looking for.
This is 429. And you had the app Adult Friend Finder on your phone.
I do not believe I had the app.
Okay, it was found on your phone.
Okay, well, I guess it was on my phone.
Okay, and there were messages from you to other individuals.
Correct.
Now, he's really not impeaching on that.
Outside of the scope of the affair with Brian, but
I don't think the court's ruling on opening the door was confined to just her extramarital affair with Brian Walsh.
well, I guess with regard to Mr. Wash, I determined that the defense opened the door. I don't know that I determined that the defense opened the door as to other.
She depicted herself as having one extramarital affair for about a 6-month period of time.
This is all in front of the jury.
That was her testimony. To the contrary, and I think it's important.
The amount of stuff that happens in front of the jury in this trial is just wild to me.
All right.
Is there a ruling? That one little clip explained my feeling this entire trial. You don't have a ruling. They're arguing in front of the jury, going back and forth, making statements, speaking objections. That was infuriating, and that happened the entire trial. That judge was sitting there and saying, well, I don't think I maybe think I did or I didn't do it. Make a ruling, tell them to move on, and tell them to stop speaking.
And I mean, in Canada, the whole thing about like no speaking objections, almost all of our objections are made with objection something, and then you defend it, right? So the thing is that you'd stand up in this situation, you'd say, I have an objection, I'm going to ask that the jury be excused. And the jury gets carted out. And then you make your objection and the court rules on it. And then you get a ruling, because the court's not keen on not ruling on something when it takes 5 minutes to move the jury each time. But the other thing is that those objections end up being a little more effective, because if each time you interrupt the guy's cross, it's 5 minutes of, okay, we're going to move the jury in and out. So long as your objections are valid and you're not getting yelled at by the court, you can shut this down, because by the time this comes back, the jury doesn't remember what the heck you were talking about. And
I'm not sure if you caught it. There were times when Shannon would make an objection and she was literally turn and address the jury with her arguments. And this was not to the judge.
The prosecutor does it too. They both do it. And it's one of these things where this right here, the three, 1, 2, 3, the three of them. And it's the male prosecutor that does it the most. The three of them together are like the personalities that you cannot put in the same room. The two attorneys get on each other and they start whining back and forth, like literally like children, like they forget all decorum. And now that's a strategy that I've seen employed by different attorneys. There's an attorney that I litigate against occasionally who has this. It's like the one attorney that knows how to get under my skin. And I hate it. I hate it because I will get through an objection and I'll be like, what the hell was I just saying? Why did I do that? Because they got under my skin. These two both get on each other's skin, and where a judge would usually come in and be like, children, shut up. This judge is like, I'm going to foster the debate between the two of you.
I'm going to let you fight it out right here.
And some of the stuff that goes before the jury is like wildly prejudicial.
The court, there was some like courtroom design issues that came into play as well, because the walls are paper thin. There was even a point where I think Shannon was up talking and she like paused because someone was making noise, and it was from the other courtroom. Okay, and it was interrupting her presentation. Work around it. Find a way to make it work, man. I mean, can we stop with this line of questioning for a second and return to it, and maybe do a sidebar when the jury is in deliberation or in the back room? Like, work around it. And then her parting shot. That was the other thing about it. That parting shot, well, this will be exciting. That would have gotten most attorneys sanctioned. I think there's more. There's something about blushing, she said as well. It was really quiet.
She gets there. Here, it's coming.
It is what it is. All right, well, go ahead. But
I won't delve too far
Okay, yeah,
into it, Judge.
really, this jury has been here a long time, and
I respect their time, Judge. I'll be brief.
No ruling.
So, Mrs.
My
Crumbley,
blush.
I'm sorry, this is not a laughing matter. Mrs. Crumbley, on Adult Friend Finder, we see messages from you in at least of August of 2021, August the 4th, 2021.
Okay.
Okay, and you don't dispute August the 10th of 2021.
So his argument is
No.
basically she's a
August 11th,
slut, so therefore send her to jail.
And more importantly, November 21st, 2021.
Yeah, I hate this guy.
Okay, and more important than that, November the 28th, 2021.
No,
Okay, you don't dispute that evidence was found on your phone.
I don't dispute it.
Okay, and you don't dispute that it wasn't just you and Mr. Malash meeting after work hours. It was with you and Mr. Malash arranging with other individuals to meet after work as well.
No, I only met with Brian during work hours. The times that we were at the hotel, I was on business. We did arrange for other people to meet us there.
So Sunday, November the 28th. You remember that day? It was the day after you took your son to the shooting range.
I don't remember it.
You don't remember that day?
No.
2 days before the high school attack?
No, I don't remember what I did that day.
Okay.
Yeah, gee, did
Well,
something else more memorable happen around then?
27th with the firearm. You remember that?
Correct.
All right. Now, November the 28th, 2021, you spent your time arranging a meetup with somebody on Adult Friend Finder.
I never met anybody on Adult Friend Finder that day.
Arranging a meetup.
Oh, okay.
I'm not just talking about the time that you spent physically with somebody. I'm talking about the time that you spent and devoted your energy to setting that up.
Okay.
And you'll agree with me, it's not just the time period at the Costco parking lot or the time period at the hotel or the time period on the trip, correct?
That's the only time I met with people.
Right. But that's not the only time that you devoted your own personal time and energy and focus to that, is it?
I guess I don't understand what
Who
you're
the
asking.
cares, dude?
Well, these meetups didn't just happen by themselves. You had to set them up.
Like, we're gonna like, you know, I bet in the intervening time you spent time going to the bathroom, didn't you? You slept. You know, you shoveled the walkway. You whatever. Like, of course she was doing all sorts of other things. The reason why he's focused on this instead of like,
Is the
you know,
insinuation. It's the insinuation.
yeah, you didn't care about your kids because you were off, you know. Yeah.
The thing is, there's a point he's making that's a legitimate point with a foundation in this case, which is
No,
the
the other
time.
point he's making
No,
that is on the top of his head.
Hear me out. Hear me out. There is something to be said about a parent that is entirely preoccupied with their own life, right? That they spend no time towards their child. There's a way to make that point without focusing on this. Like the fact that this has now dominated his cross-examination for the last 4 minutes of time when you have a plethora of things to go through. I mean, how about the journal? Are you going to cross-examine her on that? No. Nope, sorry. Spoiler alert. No, he doesn't. He doesn't cross-examine her on whether she knows whether there was a journal, whether her son journaled, whether she observed anything on the phone, whether she looked at the phone. He doesn't cross her on any of that.
Because he
sticks
doesn't
to
want to. He
this.
knows the answers. He knows that the answers to that are detrimental to him. Like, that's why he doesn't want to cross on that, because the answer to did she know about the journal is no. So all he's got is character assassination. I mean, yeah, there could be a
and pulling on the
legitimate
heartstrings
argument.
as well. He pulls on the
Oh, yeah.
heartstrings with I mean, think of the children was their whole case. Think of the children.
Yeah, we
we're not
can't
talking about
bring
our
them
son.
back. You shouldn't do it for, and then they list the names.
Don't convict Jennifer Crumbley for the hundreds of kids who had their childhood ripped from them as
And
they
here's
attended
their
high school.
pictures again.
Yes.
Like, it's like, come on.
I get it. The thing is, that's part of their job. Part of their case.
No, the
is
job
that-
of a prosecutor should be to conduct their case, not, you know,
That's correct.
based on honorable principles, not just what sort of tactic can I pull to possibly get a conviction out of this. It should be based on, you know, and so when there's a shitty argument that might work, their job is to not make that argument.
And
Like,
that is my problem is there are arguments that he has. Like, he has arguments at his disposal. The evidence that I saw elicited early on in this trial, that journal, man, the journal and the homework, the homework that presumably came home in his backpack every day, the journal and the homework. Why do we hear none of that during cross-examination? That's my point.
Because
If I
it's
was
not a
doing
good-
cross, I'm going after that. I'm saying you didn't look at his homework. You didn't see the homework endless times. Now he hits one homework assignment. That's it. Nothing else. None of the other 30 or 90 pages of homework where the drawings are there. None of it. Like, there's a point that he can make a point. He's just not doing it here.
The thing is I think that they know that absent emotion, they're looking at a losing case. And so
I think there's
that's
bad
where
blood.
I think they're going.
There's bad blood between these two teams.
There's
And-
gotta be.
And this morning,
yeah.
in the piercing the attorney-client privilege thing that happened this morning with the
Oh, yeah.
text messages between Jennifer and Shannon. Oh my goodness! I think looked at that and saw what the defense got out of that, and it was nothing. It was literally there was nothing. They were trying to prove the element of fleeing, which they don't need to prove, and it's not solid. The evidence it could have been James who made the text and everything else. It's all right there spelled out in the texts. I think they were trying to get Shannon on prosecutorial misconduct or something like that. If they could prove that she was misrepresented something to the court and actually, you know, they weren't ready to turn themselves in. Think that's what
But they didn't. They get it, and they get the argument, and that's the other risk of putting your client on the stand, especially when she has already kicked doors open. Is you run the risk that she's going to kick the door open to privilege, and the judge makes the ruling and basically says, "I hate doing this," but it was one of the only rulings that she made. She doesn't make rulings.
She muses out loud and then just stops talking about it, and then everything just moves on. And there's the objection. The objection was lodged. There's no sustained. There's no overruled. It's just you just have to assume that that you're done with the conversation and then proceed.
Which is that makes an appeal impossible because you don't have a ruling. You need to hammer the judge and say, Judge, I need to hear your ruling before I proceed with questioning. Like you need to. Otherwise, you don't preserve the appellate record.
Correct.
You weren't driven there. You weren't dropped off there. You set them up with somebody else.
Correct.
And that took your time and your energy and your focus to do so.
I don't believe it took too much time and energy, no.
Now, you told this jury that when your son texted you that he was seeing demons and bowls flying off the shelves, that was in the spring of 2021. You recall that evidence, right?
Correct.
You don't dispute that that was on your phone.
No.
You don't dispute that at some point you read those messages.
No.
And you don't dispute that your son said at least one time, can you please text me back?
Correct.
You don't dispute that when you're at the barn, your other messages show that you can take pictures, send pictures, and receive pictures.
Usually I'm at the barn. If I take pictures and I try to send them, they don't go through right away, or I won't send them until I hit a spot where I actually have service.
So in Exhibit 423, the Facebook message chat between you and James, the chat that you deleted, there are a number of pictures that James sent to you.
The number of those little side comments that happened in this trial, unprofessional side comments. And here's the thing. I'm not minimizing that at all. I completely understand that there was loss of life, and I made it very clear I could not sit on this jury. I would be shattered. I could not possibly. I don't think I could give a fair and impartial reading from a juror's standpoint. The video that was played
should never have been played. There was no reason for it. The court should not have allowed it.
Because you don't have him on trial. It's not him.
He's not on trial.
This
and
is the mom.
It is undisputed that there was no dispute as to whether or not the kids were dead, right? That's not something you need to prove. It's just, you don't need to show the jurors the gore to address this issue. And the only reason they want to do it is for the emotional argument.
They do.
And
they want the emotional argument. And the thing is that
the thing is
fled.
And for the people in the chat who are like, hey, I want her to be convicted, it doesn't stop with her. If they convict her, the next thing that happens is some kid, some mom who's working 3 jobs to feed her family, the kid gets involved in gang life because mom is too busy trying to keep everyone, sheltered and fed. And the kid goes and takes part in a drive-by. Does mom go to jail on that one? Because this opens the door to that. And then it opens the door to
joining gangs, stealing.
Your kid got
fights.
drunk and ran someone over. The burden that this is going to put, because parenting is a tough job. And, I'm not a parent, but I deal with many parents. And the thing is the standard can't be perfection. There are plenty of people who do their best and still kind of fall short of either achieving the goals or just fall short in various ways. And we can't have a society where every parent is at risk of jail if they step off of the path, because that doesn't go well.
I want to give, because RA had a good explanation for this. Scott.
I'm not sure which one they're talking about. I was going to say, I've got 6 kids. Okay. And I don't have to, I hope and pray that none of my kids ever are involved in anything like this, but I don't have to look too far back to think of a time when one of my 6 kids did something really, really stupid. Something we, didn't ever think that we'd have to tell them not to do. I had a 7-year-old son who decided he could get out on my 12 pitch roof, and I've got like a 3-story house, and he just wanted to see if he could do it. Okay, I never thought, don't climb out the upstairs window to stand on a 45-degree angle pitch on a bad old shingle roof. It's not safe. I never fathomed that would happen.
Now, can I push back on one particular topic that the chat is also on? And I'm just making the argument. Okay, the issue is also that you have these massive red flags, behavioral red flags. You have the drawings, you have this, you have the behavior. They're there. They are there, and mom acknowledges them, like this text in 2021. And then there's the purchase of a firearm for this child's firearm. Now, I understand that is both lawful. It is nothing wrong with that. You are engaging in an activity that is meant to, calm your child. But it's one of those things where these issues are going on with him. The gun plays a factor here, the purchase of the gun. And now she tries to offload it and say it was all dad. I don't buy that for a second. It was both of them that did it. And my question is,
I mean, she doesn't seem to actually know a damn thing about guns.
No, she doesn't. The prosecutor makes a comment.
I can fully imagine that she's like, dad's taking care of the gun. That's his thing. Right. So that to me makes sense.
But then the argument of hiding the gun and not locking it, that part also, that's a problem for me. Like if you just hide it and you don't have appropriate safeguards to lock the gun up. Now, you still haven't gotten me to the point where you make her responsible for everything that takes place with that.
Because it wasn't a law at the time. It wasn't a law to have the gun locked up. So they're still doing something that is legal. It's like,
is it a reckless disregard in the circumstances that you have?
The point that Shannon brought up on this, and I think she grazed across it, and she just should have spent a lot more time on it. She said that actually there were 3 guns in that house, 2 22 pistols. One was a Derringer, one was I forget the other one, and then this later one, the 9mm. The 2 22 pistols existed in the house for a long time. In that case, with the 000 lock, okay, and nothing had happened. The guns were a part of this family's life. If you look at the timeline they put up, the state put up at the end of trial, they're like 3 times in the last year that they've gone shooting at the range. Those are the 3 times. There was no indication that there was a problem with guns. Their son had BB guns. He would shoot all the time out in the shed, and there's like BBs and cartridges.
Get me past the homework. Get me past the homework.
The homework's a tough one because Jennifer of her own says she was constantly, even sometimes 2 times a day, in there watching online to make sure assignments were turned in. But I think she was more focused on the grade side of what's being turned in, and not on the where's the homework. Let's work through it together. Because 50 sheets, I think that's what they found. 50 pages of drawings.
Yeah.
Backpack, and we don't know if they were ever graded, if they were never turned in. They might be empty sheets, they might be returned items, and every single one of them passed through the hands of a teacher with a drawing on it that's a little bit violent or disturbing. That'll come out in the civil case at the school.
If you're a school, and this part, the school's conduct in this regard is something where you want to talk about civil liability. I think the school has it, and so does mom. Civil liability, they both have it. All of them have it. Civil liability, it's being passed around, right? Civil liability is there. 50% plus a grain of sand, it's there. And the school definitely has it. You're telling me the school had all of these homework assignments physically turned into this teacher, and the level of alarm that they raised was, hey, after how many assignments, let's bring you in for a meeting.
And the thing is, if you've got the school with all of these experts not throwing up flags, mom is expected to know better than these psychiatrists and psychologists and counselors.
And now I'm back to where I am with this case in general. I don't like this application of law. I have a fundamental predisposition against someone being held responsible for the independent actions of a third party.
Especially when that person was tried as an adult or charged as an adult.
Charged as an adult.
Yeah.
And it is so difficult. But I also want to make very clear, I'm not mistaking, or I'm not basically just saying mom's behavior is completely fine, all well and good. I'm not saying that at all.
No, it's just what, there are very few parents who pass the standard of perfection. And lots of parents, like, their kids do something stupid, including in ways that that could actually be extremely harmful. You know how many parents I've talked to doing criminal defense where it's like, hey, so your kid, as it turns out, was, driving drunk, and and parents who are just like, what? Or, hey, your kid was at a party, and they're like, oh yeah, he's at a party and he had drugs. Oh yeah, I guess he's experimenting. I experimented a bit. I'm like, and he was selling fentanyl at the party, and they're like, oh.
What? Like fentanyl? Like no, there's no way. It's not my son. It's not my daughter. It's not them.
Exactly. And
He
it's
would,
like,
he would never do that. Yeah.
He would never do that. They would never do that.
but then you bring him into a room like this and you start, going through all of like, well, didn't you notice this warning sign? Didn't you notice that warning sign? And by the end of it, you're going to end up with somebody who looks pretty guilty. Like, well, sure, I knew my kid was experimenting a little, but, I didn't step in. Like, everybody thinks that they will look fine in the, everybody sort of assumes that if it's them in this room,
They're gonna catch it. They would see
that
it.
they're going to get
would
like
know.
what they would consider a fair hearing too. I'm not like this, and surely that's what the court would hear, and that's what the police would hear. And I will tell you, that's not how it works, because what'll end up happening is, you'll get a very different portrayal of you in that courtroom than the one you think is you. And
Let me address a comment that I saw. I really do want to raise a point with, and it's one: he wasn't old enough to take a driving test. For fuck's sake, stop making excuses for their decision to buy a gun. One, I'm not. Two, what kills more people, teenagers in vehicles or teenagers with firearms?
it's not even close.
It's not even close. It's not even remotely close.
And so in Canada, you can get a minor's license to get, like, for a kid to possess a firearm real freaking early. Because, and this is one of the things where there's a big culture gap in Canada and in the US, which is that, like, people in cities are like, oh, you shouldn't ever have a gun until you're, whatever. Whereas lots of people who have grown up around firearms are like, the appropriate time to start shooting is like 8.
Because it's when you teach them the ramifications of the firearm. It's and this is the thing. This case should not and cannot establish a rule. It cannot establish a rule regarding the appropriate use of firearms. It can't. And I know that the comments are going to hate me for that, but I learned responsible shooting in Boy Scouts. When I was, how old was I? 12, 11, and how to responsibly use and safely guard a firearm. And there were firearms in my house, and I knew how to responsibly use them because I was taught that early. Now, it's different with every single case. And I do have a problem in this case. I have a problem with the parents buying the firearm. I have a problem with that in this particular case.
I don't think it was advisable.
me to
I just
criminal.
don't know the criminal. That's the thing.
Yeah. I don't think you've gotten me to criminal. I think I have a problem. I have a problem with it. I have a big problem with it. I don't know if you've gotten me to criminal yet.
I can see neglect. I can't see gross neglect. You've convinced me that they're not as good a parent as I hope I am. Okay, that's what I see in the evidence.
As not a parent, it's really easy to look at parents and be like, hey, you're screwing this up. And the reason why is I'm the guy who is, well, I was going to say I'm the guy who's coming at this fully rested. but I don't think I've been fully rested in my life. But, you know, the parents are waking up at 3 a.m. The parents are running the kids to their, you know, whatever early morning practices. They're, you know, they're dealing with all of this stuff. And it's always easy to judge from outside. I'm really
Also-
concerned about criminalizing parenting, you know, and the degree to which we may do that, because
It's
it
the
gets
other thing is
risky.
pass a law. I hate to say it that way, but the way that we give notice in this country of what activity is permissible and not permissible is there are laws, there are regulations, there are laws on the book. And the laws are there to tell you this is criminal behavior, this is not criminal behavior. It is within the prerogative of the body politic, if they so choose, to pass a law. Now, you have to persuade a lot of people to do it, and you have conflicting opinions, but that's politics. Pass a law. The law is what tells people what is legal and what is not. If there was a law in the books about the appropriate safeguards for firearms within a home, right? If Michigan, yes, Michigan. If Michigan had a law on the books that said any firearm purchase must be appropriately stored within a home, and by appropriate storage we mean locked with a passcode that is known to the rightful, passed a law, and then
Would
hold people
probably be
accountable.
unconstitutional, but
But then hold people accountable.
that law would probably not pass Second Amendment muster because of Heller. Like, one of the major bases for having a firearm is self-defense, and you can't if it's locked up.
And then pass a constitutional amendment.
Yeah,
That's
a big ask.
it's a big ask, but again,
but don't do it backdoor, like via backdoor method.
the founders put a big hurdle. Like that's the thing. The founders required the big ask, and and we got sideways on this one because the focus of this was really supposed to be on the lawyers and the antics, and some of the evidentiary rulings that I really couldn't understand how they were being made, and a lot of it came with. Let me see if I can't pull this screen up. Give me 1 second. I know people are going to disagree with the hell like crazy, but honestly,
I have a sort of principle, and it is like you can measure the degree of freedom in a society by the gap between like where conduct becomes obnoxious and where it becomes criminal. And the smaller that gap, the less free you are, because inevitably you will screw up. Inevitably there'll be a moment where you do something that is below the standard of perfection. And
if you want a good example of that, buy a house in an HOA.
Yeah.
Buy a home where somebody else can control and change the rules as to what you can do with your property. And I realize some people are big fans, but it's very easy to run amok from the HOA and find yourself in trouble.
And to the point that like is being made about this, I can guarantee you every single parent in the chat right now, if you gave me your phone whereabouts, your tracking history, I could make you out to be a neglectful parent.
Oh, hell. You don't even
it'd be very easy.
You don't even need the parents.
They took 7 pages out of 20,000 messages. And that was the
I actually really liked that part of the close. Where she's got the big stack of things
with post-it notes, with bright post-it notes, so you can see just how much it is.
The one thing I would have done if I was her, and I mean, I would have probably gotten in trouble for this, but is push the stack over and just like let it fly. I mean, she's gonna have to pick it up later.
Don't worry, Garner. I'll get this one sheet at a time. Let me just gather up all these irrelevant.
Well, you just like
this judge would have let it fly. This judge would have let you do it
and tip it over and say, you would never find the texts that the prosecution is relying on in this pile. It is literally a needle in a haystack. And, you know, just let them see the giant mess that would make. Because stacked up, it's impressive because it's like up to her chin. Spilled out over the floor, it would be a paper explosion. You're gonna have to pick that up because otherwise the clerks will never forgive you if they have to clean that up for you. Like, you would be persona non grata in that courtroom. But
she did that twice. She used that prop twice, and the first time the judge actually asked her to move it. She was worried it was going to fall over.
yeah, and
she
I
needed
would have
help.
just like, let's have that be a big paper explosion. Like,
Yeah, I have a problem with a lot of this case, and a lot of it actually is a lot of it's focused around this particular issue. And the journal. We're gonna get into it. Let's play the testimony. If it plays.
Yes, I do.
Are there facilities available for that?
Yes, there's a facility on this complex called Common Ground that's available for that.
In reviewing the phone logs of Jennifer Crumbley, is there any indication of any phone calls to a facility of that sort?
No.
In fact, any.
Do you know what he's talking about here? Involuntary commitment.
yeah. And the thing is none of the people who dealt with this kid thought that he needed to be involuntarily committed.
They were
In
cool with sending him back to
hindsight-
class. Yeah.
In hindsight, we go, sure, absolutely. But if you don't have the benefit of that hindsight, nobody saw it, nobody said it. And so mom is on the hook because, what about the people whose job it literally is to assess these things? Because
Let me make it clear. This case, and I know we're early, this case fucking sucks.
oh,
And
absolutely.
when I say that, I mean the failures occurred at every single level. Every level, the failures occurred.
But the thing is, everybody thinks they'd see it in hindsight, and
You can't. You're in the moment.
I'm gonna talk about Columbine. Remember Columbine?
Oh, really? You're gonna do the CP? Okay, go on, Ian.
So
Please keep my stream up.
First with the
Post-
pizza, and now with this.
post Columbine, there was this big push of we should have seen it. And so they took all of the signs that they should have seen and they used those to go after like every weird antisocial kid. And you know what? Based on the statistics, none of them would have been an issue. But we went and caused tremendous damage to a whole bunch of people who just like kind of felt like outsiders at their schools. And
Upside down. I don't know if you're a troll or not, but this is not about me owning guns. This is about me.
it's
really
not about
having an
guns
issue.
at all.
It's
It's
not
about
gun. You can talk about
parenting.
knife. You can talk about explosions.
about-
You can talk about anything. Talk about pick a poison. Pick a.
It's
cough.
about how you treat children. The other one I'll mention is everyone's probably heard of like the big three, like the deadly triad, of bedwetting, animal abuse, and what's the other?
Bedwetting, animal abuse, and it's not the journaling. It's
Fires, starting
Yep.
fires. You know what the predictive value of that is? Basically zero.
well, and
Because what happens, it's predictive backwards. If you are looking at a serial killer, it is likely that these things are in their background.
You'll find it.
However, that is because most serial killers were also abused as kids. And these are symptoms of having been abused as a kid. It's a symptom of a child in extreme distress. But most kids who were abused don't go on to be dangers to anybody. But when we identify these things as things that parents have to respond to or that schools have to respond to, what that ended up doing was that resulted in a whole lot of abused kids being specifically set aside and targeted as dangerous. And as a result of that, those kids did not get proper treatment. They did not get anything. They got further victimized. So when we set these
they got
rules,
social disorders because they were isolated from people too.
so yeah, when we set these rules, you end up with huge issues there.
Let me add a
So-
caveat. Let me add a caveat that's really interesting, and it's actually one that comes from personal experience and experience in my profession. I have an experience with several experiences where the child comes home from school with a report card or with a teacher's note, and the report card has glowing results. Everything is great. Well, that doesn't seem right to the parent. The parent calls and the parent says, but I've noticed that my child has trouble doing ABC. Well, yeah, she or he does. They do. They could use some more time with that. And I've noticed that they have difficulty. And then the parent says, I've noticed they've had difficulty focusing. Yeah, I do have to interrupt them a lot. I do have to redirect them. And then they say, well, I've noticed they have behavioral issues where they can sometimes act in a way that is bullying. The teacher goes, in hindsight, that does occur. Why isn't that on any of the material that comes home from the school? Why? Because the school is concerned about them. They're concerned about them getting in trouble. They don't want to deal with the emotional parent. They don't want to deal with the parent that's a problem. When I say that this was a failure at every level, I absolutely mean that. I mean that you didn't have the parent that was shooting back at the school and saying, well, I've noticed this. I mean to say that you have a child who is expressing that they've reached out and the parent's going, I never saw that, never saw a problem. And then you have the school that's just going, yeah, we'd like you to come in, but we'll send him back to class. Every freaking thing about this case is an example of how we need to fucking change a lot of this structure.
Here's the thing. If this shooting hadn't happened and you went 5 years ahead, his story would be absolutely unremarkable to the school administration because they deal with a lot of problem kids. And it would have been like, okay, if he had just gone on and, let's say he drops out or he graduates high school, gets a job doing drywalling. None of them would really remember this kid as standing out in any major way. They might remember that he was there because, you remember people you ran into, but it wouldn't be like, hey, do you remember that really weird kid?
Well, we're talking about failures. If I can interject just for a second, I'd love to get your feedback on this. The school, a lot of people are saying if only they had searched the backpack. Legally, could the school search the backpack at that point? Is that a hurdle is that an opportunity they missed?
With that homework, yes, you damn well believe I could have. If I see the homework and the homework has that on it, I've got enough to search the backpack. Ian,
Can't they
agree or disagree?
I mean, different standards where I am, so I don't know.
School is
the
not
school's
it's
not-
not public.
they're-
It's not public. They don't have the same rights as parents. They have significant rights, but the school has a special interest in protecting the remaining students in the school.
And I think that the school has no issue legally with just saying either you let us look in the backpack or
you can't go
you
back
go
to class.
home.
Yes,
Like-
they can absolutely say that.
So, they could have said that and hey, either we see what's going on or you go home.
The
Done.
school also has a mandatory reporter position. They have to mandatorily report to CPS and to the appropriate authorities when there's a concern. They're a mandatory reporter, and
no calls were made.
no calls. It
Yeah.
was a parental. That's what I mean when I say it was a failure on every level. This was literally a disaster that was a making of so many different factors. And the thing is and the teachers in the chat, you guys can comment on it, but I can tell you right now, the school has grounds to do the search. Absolutely. And the only consequence to the school of doing the search and this is possibly evidence getting thrown out. But you know what happens? The search finds the gun.
I think they could have been sued for tens of dollars if they'd gotten the search wrong. Hey, you violated this kid's rights.
It would have been on the front page of the student newspaper that week.
Yeah, well, you win that lawsuit. It's okay, what are the damages? Well, he was mildly inconvenienced, so $250.
If I get a phone call that says that one of the mini mischiefs was acting in a way that caused the school to search his backpack, and they found something in the backpack, drugs, something. I'm not stomping my feet and saying suppress, suppress, suppress. I am respectfully, well, my dad would say go pick a switch. They can search. They can search it. Now the problem here's this bit of testimony is the journal. Now this one is a content warning.
Great pause game, by the way.
It's not bad. Content warning. The subject matter is very challenging in this particular part. This journal, I think, is one of the most egregious things. Where was it? I had it. Thought I had it queued up. Oh, here it is, back here. Nope. And he's talking about it. Give me 1 second. It's there it is. Here we go.
From some of the dates that it was written from the back cover to the front. The earlier dates seem to be on the back side, if that makes sense to you. Like I said, it was about 22 pages total in length.
Judge, I'm going to mark this for demonstrative purposes only as exhibits, so the record's clear. I believe that's 428 again for demonstrative purposes.
Demonstrative meaning the jury's not going to get this back in the deliberation room.
I'm sorry, yeah, please take your time.
Is that right?
Enjoy it
Ian?
while you can.
Yeah.
It's just.
Okay, thank you.
Yeah.
This is the worst pair of scissors I've ever seen, by the way.
This
Or just he's never used a pair before. I'm not sure which it is.
this part was torture. Can we get him scissors and can we give him some gloves, please? Like, is it that hard?
You know why those scissors might be awful is sometimes they have like blunts. No, those look like they've got a point. I've seen like blunt, like children's scissors in courtrooms sometimes because you might need to hand them to like an accused person.
It could have been that he was using them like a pocket knife. So
Yeah, but we're not going to use gloves. No gloves. We're not going to bother with that. Why bother?
Well, I don't think there was an issue of like fingerprinting or anything like that. I'm not.
No, I get that. I get that. Can't we just have a standing rule? Like, it's not hard. Put a box of nitrile gloves up there. Like, just please.
Holding your hand. That's what's depicted here in Exhibit 12 that I'm magnifying.
That's correct.
Okay. Now, these papers that we just talked about, we said over 50 with different pictures of weapons. There's no evidence that was ever turned into the school. Is that correct?
One leading AF. People are asking who this
they were
person
leading
is.
all the time.
This is the detective that was in charge of essentially every division. So this detective was overseeing. This is their wrap it up witness. Like, this is their final detective, the final witness who basically brings everything together and presents a package to the jury of their best case. He's lead detective who basically orchestrated the entire investigation. And what he has is the journal. And the question that was asked by the prosecutor right there is, we don't have any evidence that these were ever turned in, right? Leading, he doesn't know that. How does he know that? Where would there be evidence of if it was turned in or not? I have issues with both attorneys and the judge in this case. I have issues with the whole thing.
Yes, I have no evidence of that. Okay.
Well, what does it matter what you have evidence of as opposed to?
I have.
Okay. Out of
Yeah,
that
I
notebook,
hate that.
How many pieces of paper have actual writing?
22.
And does one of those 22 pages include just a drawing and a quote from a book?
Yes.
Okay. Now, out of the
This also, by the way,
remaining
tells you
21,
that this
how many
witness is
reference
way prepped.
school shooting?
Every single
because
one.
nobody counts the pages.
So there are some that have been admitted, some portions of that. I'm going to go through those with you. Just so you're aware, we've numbered them to keep them keep them straight for you as well as the jury.
Love you
Number
too.
one is the drawing, page number 1. Page 22 would be the back cover of that journal. Is that clear?
Yes.
Okay, and the back cover of the journal has actual writing on it as well.
No,
Rob,
I hate that wheel.
You brought up something. I think you were in my chat when this was coming up, and you brought up some points about questioning the source.
I have a problem with this journal.
I want to hear more about that.
And let me do this. So the journal itself, this is Ethan Crumbley's journal. These are his words, his written word, right? This meets the very definition of what hearsay is. Like, this is absolutely 1000%, especially the passages that they're going to read into the record. Let's go to the passage first, and then we'll explain it with the passage.
Yes. 401.
Are you gonna go through?
Only the ones that have been.
I understand, 401.
They're all 401.
Oh, they're all 401. I see it, thank you.
Correct.
Okay. You said it individually, so I got confused.
Okay. So this has been admitted as page 401. Sir, in reading the journal, were there passages in there indicative of a request for mental health help?
Yes.
Can you read what's been identified here as page 6 of that journal?
Yes, the shooter writes, I have zero help, as you can see in the bold, for my mental problems, and it's causing me to shoot up the fucking school.
We'll move on to page 5. Could you read this passage, please?
In this one, the shooter writes, I want help, but my parents don't listen to me, and I can't get any help.
Well, this is page 19. Can you read that?
Yeah, this
Yes.
should not have
Shooter
come in
writes,
this
my
way.
parents won't listen to me about help or therapist.
Sir, in that journal, were there entries about the shooter's desire to obtain a 9mm handgun?
Yes.
This is also exhibit 401, page 22. Could you read those for us, please?
Yes. The shooter writes, I want to shoot up the fucking school so badly. Soon, I'm going to buy a 9mm pistol.
Sir, were there any passages regarding the shooter's plan for the actual shooting?
Yes, there were.
Okay. Here's page 3, also exhibit 401. Could you read that, please?
Yes. Shooter writes, I'm about to shoot up the school and spend the rest of my life in prison.
Were there any journal entries about the shooter's access to the 9mm handgun?
There were.
This is also exhibit 401, also page 3. Could you read that, please?
Yes, sir. The shooter writes, first off, I got my gun. It's a SP 2022 Sig Sauer 9mm. Second, the shooting is tomorrow. I have access to the gun and the ammo. I am fully committed to this now. So yeah, I'm going to prison for life, and many people have about 1 day left to live.
Thank you, sir. Now, is the journal written in normal size fonts, or are there certain passages that are bolded and larger than normal size fonts?
Both.
Okay. And were there drawings in there as well?
There were drawings.
Okay. Were the drawings small or were they large?
Yeah, there were large drawings.
What's an example of a large drawing?
Yeah, so there was a large drawing in the.
This is enough to make the point. If this were the trial of Ethan Crumbley, 1000% that journal comes in. That is, those are his words, his writing, it comes in. It's an admission against party interest, period. That comes in. This is a really unique situation, and it's one that I have a big problem with. The defense attorney appropriately filed a long motion in limine asking to exclude the entirety of the journal. The judge took that under advisement and, ruling from Chambers, I believe, ruled that the journal itself would not come in, but the prosecution would be allowed to use a few select passages, the ones that were just read. And this is one of the issues. One, what is the definition of hearsay? The definition of hearsay is an out-of-court statement by a declarant, someone who is making the statement, that is intended to be introduced to prove the truth of the matter asserted.
And a
Example.
statement can be a writing, a facial expression,
Anything.
a nod. You know, it's not just like a verbal statement.
Correct. So hearsay is it's an absolute rule. There are certain exceptions to the hearsay rule, and you have to overcome several burdens together. But first, the question is it hearsay? Yes. The reason the prosecution is introducing these statements is to prove the truth of the statement, namely that I have asked my parents for help and they have said no, or they are ignoring me, or I am going to do this tomorrow, or I have these things, right? They are trying to introduce that statement to prove the truth of the statement, that the parents haven't actually done anything. Okay. So first of all, it's hearsay. Now you look at the exceptions. What can I use as an exception? Is it an admission against a party opponent? Is it something that's detrimental to the person who is on trial in that moment? No, Ethan Crumbley's not on trial.
Is it a statement by the person that is detrimental to the person?
By the person
on
detrimental
trial?
to that person. Correct.
Yeah.
Is it a present sense impression? Meaning, is it an expression of a then existing state of mental or physical condition at the time? I think that's what the judge ruled on, and the judge said it was. I pretty adamantly disagree.
I think they should have had to get this through Ethan. If you want this in, call him as a witness.
And
what is the
now
relevance of this?
This is the third hiccup. Here's the problem. Ethan Crumbley pled guilty, but after pleading guilty, submitted to the court for sentencing. This court sentenced him to life without the possibility of parole. He has since appealed that sentence. During the pendency of his appeal, the court-appointed attorney for him asserted his Fifth Amendment privilege against self-incrimination, refusing to testify. Meaning that he can, it does, it makes complete logical sense. But what that does is that makes him an unavailable witness. It makes him unavailable to either party. And one of the big problems is you have a Sixth Amendment right to confront your accusers, to confront the witnesses that are brought against you. You have an absolute right that if, and Ian, I know this is different in Canada, but in the US, if someone is going to say something that's detrimental to your life or liberty, and we've talked about this in prior cases where people are like, how is Darrell Brooks able to, how does he able to cross-examine these people?
Oh, yeah.
Because he has the right to do it. You have the absolute right to face the person who is saying these things about you and either say that's true, that's false, and prove that it's false. You have the right to impeach them. This gets brought in with no ability to impeach, bolster, or get any context from the individual that wrote the words. None. And that, I think, is a massive problem. Of all of the appellate issues that exist in this case, I think this journal is the biggest one.
I'd agree. To me, the hearsay is a smaller problem than that. And when this gets redone, this is going to be a Mark Jensen trial all over again. When the appellate court reverses it and it goes back, and they're going to pull the letter that his wife wrote and say, "Okay, you have to retry the case without this letter saying it was my husband if I'm dead." I think they're going to pull that journal, and that's going to be a retrial without that evidence. That would be if I had to put my money on something. That's predicting the future.
My money is still on acquittal, and then none of this matters.
If the acquittal, none of it matters. But the Sixth Amendment issue is my biggest issue and the judge did one of the most infuriating things I've ever seen a court do. And let me see if I can't find.
I think you've said that about 6 times about this case.
Oh no, this one was this judge. I don't particularly have a great deal of.
No, it's just funny because there's a lot of that going around.
I'll have a lot of respect for the judge. Hang on. Pulling this back up. So now they're having this debate about the journal. She wants now the defense attorney after the judge has ruled that these passages of the journal can come in, this defense attorney wants to bring up additional passages within the journal to cross-examine or impeach the declarant, Ethan Crumbley, again, who's not in court. And the judge, let's just listen to it.
I believe my impeachment is very limited.
Oh, wait,
It's
hang on.
limited to 3. Because it will.
I'm not keeping you from calling him. The law.
This part.
To do those two with the claim about access to the gun. And the detective also testified to a statement about I'm going to get the gun. So I wanted to impeach him with, on 789, there is a statement that says, it's one line, however, I don't want to be caught as that will make me getting the 9mm impossible.
Now, she uses the wrong phrase a lot here. She says impeach him. And the question is, who are you impeaching? You're allowed to bring out prior inconsistent statements or different statements to impeach the credibility of the person making the declaration. The declarant in this point is Ethan Crumbley. So while she is saying, I would like to impeach the detective, she's not. She wants to impeach the person who can't be called, which, if they're unavailable as a witness in hearsay rules, there's different hearsay rules that exist for witnesses that are available to testify and witnesses that are unavailable to testify. Unavailable, they're dead, they're otherwise indisposed. You cannot call them. You cannot physically bring them to the courtroom to testify. Therefore, you have additional things you can bring in. The person is no longer there, so I can impeach them with prior inconsistent statements that might otherwise be hearsay. So if Ethan Crumbley is, quote, unavailable, she can get these statements in. She can impeach those statements with other hearsay statements. What's good for the goose is good for the gander.
Would this be the right place? Would this be the right place in the court to do that, though, with this detective on the stand, or with this lead detective?
Yes and no. There's really no other way to do it.
Kind of win else.
She could try to bring it up in her case in chief, like say, this is now context. I want to add these statements because they're now contextual and they're impeaching the statements that were brought to bear by this detective who was introducing statements by a third party who's not present. But what the judge does here is perhaps one of the most frustrating rulings I've seen in any courtroom ever.
It's not impeachment because he's not the declarant.
Prosecutor's right.
Well, I'm hamstrung because these statements are coming in by a declarant that I'm not allowed to call as a witness. And under the same...
I want to back up a second. I never said that you could not call the shooter as a witness.
I was...
Why is she saying that? I cannot call a witness and put them on the stand for the express purpose of having that witness plead the fifth in front of the jury. If I know that witness is going to take the stand and plead the fifth, I can't call them. It's prejudicial because all you're doing is trying to infer to the jury that the person exercising their right is doing so for basically proving that they did the thing. So she is appropriately saying, I can't call this person. The court's not going to let me call him. And the judge immediately backtracks. And I think it's completely fucking wrong. Completely wrong. And the judge says, I never said you couldn't call him. Okay, judge.
Okay, so defense calls Ethan Crumbley.
Wait, this gets better. Did
She
you see this part,
dances
Ian, yet?
line. Oh my goodness.
This part, this is...
Getting the vibe that would be the ruling of the court.
No, that'll never be the ruling of the court. I'm not telling you that you can't. I am not, as a judge in this court, telling you you cannot call the shooter as a witness. However, we've been over this before. We're going to go over it again this afternoon. Pursuant to case law that everybody's aware of, including a case called Jackaloni. It's 399 Mich 642, a 1977 case. No one is allowed to put a witness in front of this jury who was going to take the fifth.
Who makes the ruling on that, Judge?
Yeah.
Are you fucking kidding me? I am
She
not.
wants to
I am not
suck and
as
blow at the
trial
same
court
time.
judge. I am not as a trial court judge saying you can't call them. But we've been over this pursuant to this particular case law. You know you can't do it. Tell me I can't do it. Make a fucking ruling.
This is the problem for the appeal, right? We need something on the
Massive
record
problem.
that we can say
It's a
here's where the
massive
court
problem
was wrong.
because the defense attorney not getting her to, and honestly, this is one where as defense counsel, Ian, I know you would do this. I know other attorneys would do this. I would do this. Say respectfully, Judge, I need you to make a ruling. I'm not going to rule. Fine. I call Ethan Crumbley. Counsel, I'm saying you can't do that. Thank you, Judge.
Yep. Now we've got our ruling.
And the problem
I mean,
is, oh,
this was day 6. They've got another day. I'd just be saying, okay, I'm putting the court on notice that one of our
calling
witnesses
Ethan Crumbley.
tomorrow will be Ethan Crumbley, and we're asking
Yep.
that he be brought to the courthouse for that purpose.
You want to prevent me, Judge? Make a ruling.
Yep. Or rule that, yeah.
But counsel, you know it's against the law in the state. No, I know that I know the case law says this, but I don't think he's going to plead the fifth. I'm going to put him on the stand. Make a ruling.
Yeah, if you think
Preserve
he's
the
not going to
record.
plead the fifth, then let's have it.
This was a disgusting. You know what? I don't care. This was a disgusting display of individuals that we task with placing the black robe on them and acting as the final officiant of what is or is not allowed in trials. You call balls and strikes. You can't just have a pitcher throw a pitch down the center and say, I don't know, what do you think? You know that you're supposed to throw the ball within the strike zone. You know that. Did you throw it in the strike zone? You know you're supposed to.
No one. It's not me.
And I'll be right back.
Well, I'm
I'm not keeping you from calling someone as a witness, but his Fifth Amendment rights have been asserted repeatedly.
Make a ruling.
She keeps pushing. It's almost like she ends making the ruling. Like I'd say she, but Shannon Smith, the defense attorney, enters the ruling. I mean, that's as absurd as it sounds on the record. If you read the transcript, she's like, okay.
She I don't think she does. I think she's wish-washy enough that a court of appeals wanting to punt is going to punt. And you know what it is? When a judge says case law in this jurisdiction says that I have to do this. You know what that is? That's a ruling. Like, make the ruling. Say, I am bound by the courts above me, and my binding authority says that I have to rule against you, and this person can't take the stand.
What was her opposition to doing that? Why is she saying this court is never going to tell you who you can't call? Because that would be
appealed. She doesn't want to be appealed.
And that's it.
And she knows that by making the judicial finding that you cannot call this person, you have now opened into that second category of an unavailable declarant, where different hearsay exceptions apply.
I would say she knew that going in. She knew this going in.
Oh, no, she did. She damn well did.
And before that evidence was brought in, those excerpts from the journal were brought in, she knew that the son was going to plead the fifth. And
The cleanest
should
thing
not have been allowed because of
that judge could have done. The cleanest thing the judge could have done is say, I'm not allowing the journal in. And the prosecution still has a case. Cleanest thing she could have done. But what she did was, in my personal opinion, a disgrace. Because she made a ruling that certain parts of the journal could come in. Stand by it. You put your neck out there. You made a ruling. You said, these passages can come in. Put your fucking money where your mouth is. Like, put it down. Say, fine, they can come in. And then you now have to be held to the fire and held to account for the decision you made regarding evidence, allowing those parts of the journal in. You allowed them in. Defense counsel is now saying, you have to rule that this person is unavailable so that I can use the rest of the journal if I want. And she's saying, well, I'm not going to rule that way. Come on.
This was a long battle. This was a long battle over this topic, and it doesn't end here. I mean, it goes back and forth. I'm not going to spoil it. I'm not sure how much you want to watch and other things that happened in courts this week as well that you wanted to talk about. But
it was this part that I wanted to get through. So let me get through this.
I can't let you put a witness on the stand. Anyone, the prosecution too. I wouldn't let the prosecution put someone on the stand, knowing that that person was going to take the Fifth Amendment, take the Fifth. If someone takes the Fifth in front of the jury, it's over. It's in this trial. I can't let you do that, right? And I also asked before, aside from what is your favorite color, I can't imagine something you could ask the shooter that would not implicate his Fifth Amendment rights. His current attorneys, the state defender's office, have asserted his rights. They have said he will not testify.
I understand that. I have said I would still like him to testify, so I just need a finding by the court that under case law, he's not going to testify.
I'm not making a finding that he's not going to testify.
You can't fucking do that. You cannot do that. She is saying, I would like him to testify. I need you to make a ruling. But then she says, I'm not doing this. I'm not making a ruling. I'm not making a finding. That's the problem. This is now muddy.
His lawyers have asserted the Fifth. You're not allowed to put someone on the stand that will take the Fifth. And in reality, if they...
Here's where you interject. And here's where she should have interjected. She should have said, Your Honor, am I understanding what you are saying? This is now the court's ruling that I am not allowed to put this witness who has asserted their Fifth Amendment privilege. I am not allowed to put this witness on the stand.
what's the worst that can happen if she does call? I mean, if we could back up and rewind time, and she calls the son. What the judge then is forced, it forces the hand, right? She has to say
the hand.
Either I'm not going to sign the transport order, or
I'm telling you, counsel, I'm asking you, are you calling him knowing that he's going to take the Fifth? No, I don't know he's going to take the Fifth. Well, his attorney said he has.
But,
I don't know.
But there's no ramifications
there's
back
no
to
guarantee.
the attorney themselves for attempting
the,
this, right?
The attorney has indicated that he intends to. I don't know that from him. I'm going to put him on the stand. Counsel, I'm telling you, you can't do that. Is that your ruling, Judge? Yes, that's my ruling. Boom, clean. This was disgusting. Like, this is shameful from the judiciary. Your job is to make the hard choices. You have
Are we
to.
still on balls and strikes?
This one. Well, did you hear the last part, the last bit? Hang on.
No, I didn't.
Telling you cannot call the shooter. You could not call the shooter as a witness.
I was getting the vibe that would be the ruling of the court.
No, that will never be the ruling of the court.
Don't ever make submissions about vibes.
As a judge in this court telling you cannot call the shooter as a witness. However, we've been over this before. We're going to go over it again this afternoon. Pursuant to case law that everybody's aware of, including a case called Jackaloni. It's 399 Mich 642, a 1977 case. No one is allowed to put a witness in front of this jury who was going to take the Fifth. No one. It's not me.
Well,
I'm not keeping you from calling.
There is no case law that takes effect without you making a ruling, Judge. So it is, in fact, you.
And I can't let you put a witness on the stand. Anyone, the prosecution too.
Here it is. Wait.
Let the prosecution put someone on the stand, knowing that that person was going to take the Fifth Amendment, take the Fifth. If someone takes the Fifth in front of the jury, it's over. It's in this trial. I can't let you do that, right? And I also asked before, aside from what is your favorite color, I can't imagine something you could ask the shooter that would not implicate his Fifth Amendment rights. His current attorneys, the state defender's office, have asserted his rights. They've said he will not testify.
I understand that. I have said I would still like him to testify, so I just need a finding by the court that under case law, he's not going to testify.
I'm not making a finding that he's not going to testify.
Oh my God, make the finding.
Have asserted the fifth. You're not allowed to put someone on the stand that will take the fifth. And in reality, if they say he won't testify, I don't know what am I going to do? I'm going to insist that he testify and then hold him in contempt and put him in jail. Is that?
Well, Your Honor, I understand the court's position, but for the record in this case,
I don't.
And by the way, I understand your position as well.
I've indicated for as far as our
If you did understand my position, you'd make a fucking ruling.
Yeah. I understand the court's position. How? The court's position is incoherent.
This comes back on defense counsel just as much as it does on the judge.
Yeah, I mean, she needs to
fucking issue.
Yeah.
Judge, force the issue. Stop dancing. Stop playing a game. You know, you play the game of, Your Honor, I need this record to be okay, blah, blah, blah. I need a finding. Judge, I am going to call Ethan Crumbley. Am I understanding the ruling of this court is that I cannot call him? Do it. And the judge is going to hate you. They're really going to hate you because they don't want to have to make that ruling. They don't like it, but you have to do it. That's your fucking job. Just like the judge, it's your job. This is
our position. I've indicated I don't believe the shooter should be allowed to plead the fifth because he was sentenced. He's made statements about the crimes. He pled guilty to all 24 counts in adult court. And so I don't
So you think that's over? You think that's over?
Well, I think there is not case law that says he gets to continue his Fifth Amendment rights beyond that plea. I don't disagree with you. He's going to pursue an appeal. I don't disagree.
All right. So what would make me think he does not still have Fifth Amendment rights?
There's case law directly on point.
I know, and some of those are indicated in the letter provided by the state appellate defender's office, right?
Yes, sir.
Yeah. I understand your position. I also understand to a certain extent, I don't, even if he was called as a witness, you understand that then the prosecution would have a right to cross-examine him, right? So, I'm not keeping you from calling him. The law is keeping you from calling him. You are not permitted to put someone in jury was.
Oh my God. Oh my God. Scott, when you were covering this live, I was screaming in my car.
I was thinking, I can't wait for Rob to cover this because I want to know. Because clearly, you could tell defense was frustrated. They're like, I just need a ruling. She said, just say the words and move on. I'm cool with where we're at. I understand that's where we're at, but I need you to say something.
It's this little bit of ass covering here. Hang on, let me rewind it.
Right. So, I'm not keeping you from calling him. The law is keeping you from calling him. You are not.
I'm not keeping you from calling him. The law is keeping you from calling him.
What a ridiculous piece of bullshit.
Oh, I completely agree that she is right. She is right. She is 1000% correct.
The law does support it. It just she needs to rule on it.
Whiskey 77, you are. It's not me eating crow. I am 1000% in agreement with you. Defense counsel cannot call Ethan Crumbley and put him on the stand for the sole purpose of having him take the fifth. I 1000% agree with you.
We've been saying that all the way through. It's just that she needs to actually rule that is her decision.
And
she can't.
She's not saying it because she knows there are ramifications to saying it. If she says it, Ethan Crumbley is an unavailable declarant, which means that there are different exceptions that apply to the hearsay rule, which means defense counsel gets to bring in more ish. Like,
And
that's
like this notion that there's law that applies in the proceeding without a ruling. No, the judge rules on things. That's how the law applies in these.
yeah. And Whiskey 77, the case law. I know the case law. I know this law. I think I was screaming in RA's chat, like, you can't call someone to just take the fifth. You can't fucking do that. You can't do it. But you know who has to tell you that? The judge, because the judge makes the call and says, I am ruling that you cannot call him because you are doing it for the express purpose of having him take the fifth. And I cannot allow that to happen in my courtroom because you know what, bitch? I am the law in my courtroom.
Breathe.
Need some
Try
Zen
it.
music.
Permitted to put someone in front of this jury who's going to take that.
I
Bet
understand.
I can find some Zen music.
That's the ruling then.
Who's going to stop me, Judge? You are the law prevents you. Who's going to stop me, Judge? Thank you, Ian. Jeez, my God. Is this what is this? The Feed the Ducks?
Daydreaming.
Daydreaming. This is nice. It's calming.
I feel better already.
It's lovely.
Ooh, it's got a beat drop too.
It does. This entire trial has been, between the subject matter and the lawyers that are arguing it and the judge that's overseeing it, one of the most infuriating things I've ever seen as a lawyer. And I can't.
So you put some of this on Shannon, right? You say she's partly to blame. She has to push this issue, and she has ways to do that. I want to see if there's another mistake she made. There was earlier in the trial, right after the case in chief for the prosecution ended, she has the opportunity to file a motion for a directed verdict or a judgment of acquittal.
And she didn't.
And she brought it up, and she didn't. She made it. She said, "Oh, you want me to do it now or later?" She's like, "Oh, you can do it later." Doesn't it have to be timely at some point? I mean, if the jury's
Yes, it
out
has to be
deliberating,
timely.
is a little too late to put that in?
You have to make it at the time. Like, you have to make it and you have to preserve it. Like, one thing that I will say about Dick Harpootlian, who we'll talk about later, is yes, he's
a
annoying
bulldog. He
AF.
doesn't give up.
Correct. He's annoying AF, but he preserves the fucking record. Like, that record, Poot makes a clean record. Poot forces the judge to make those rulings and does it repeatedly. So if the Court of Appeals is ever like, point to me in the record where you preserve this objection, Poot's like, you
Jack
want
I
that
objected
indexed
to it 18 times.
alphabetically? How do you want me to give that to you? Because here's all the points. The problem is, and here's how this is her version of preserving the record. Listen to this part.
That the law doesn't allow me to. Is
Yeah.
that,
Permitted to put someone in front of this jury who's going to take that.
I understand.
Yes.
That's the ruling then. That the law doesn't allow me to. Is that correct? Okay.
By smarter, higher courts than this one.
If that's the ruling, is that the court is going to follow the law the court
I'm
said,
going to follow the law.
then I've preserved the record and I'm moving on.
No, you
So-
haven't.
So then these statements are coming in. They've come in as present sense impressions.
I could
And,
argue that on appeal, about a record being preserved there, but I'd
Yeah.
have to argue it.
They're gonna punt it.
And-
They're gonna punt it. They don't want it. They're not gonna take it up. It's
Yeah,
not preserved. It's not
This is-
preserved.
you've got to just not let it go. Like, hey, unless this court makes a ruling that I can't call him, I am calling him.
Yep.
And if this court doesn't want a mistrial tomorrow, make the ruling.
Prevent me from doing it because I'm issuing a subpoena to the sheriff's department. Let me tell you why that's not. Listen to the words said. Hang on.
We're hanging on.
Did she say yes? Did she say that's my ruling? Did she say anything, or was she just adding to counsel's own argument and internal monologue?
We didn't hear it. I think you'll play it on your side.
That played on my side. That's my bad entirely. Gosh, man, it's really
Yeah.
annoying to me.
And,
But it's about as clear as it is.
Right?
Play it on our side as well.
Yeah.
There's nothing there.
I understand your position. I also understand to a certain extent, I don't, even if he was called as a witness, you understand that then the prosecution would have a right to cross-examine him, right? So, I'm not keeping you from calling him. The law is keeping you from calling him. You are not permitted to put someone in front of this jury who's going to take that.
I understand
Yes.
that's the ruling then, that the law doesn't allow me to. Is that correct? Okay.
By smarter, higher courts than this one.
I'd argue it's there.
If that's the ruling, is that the court is going to follow the law the court said.
I'm going to follow the law.
Then
It's funny though.
I preserve.
It's not clean enough.
If that's
There is
the
a
ruling,
correct, but it's
the
not.
court's going to follow the law. That's what it is.
That's it. It's
Well,
not
she
clean enough.
says if that's your ruling, then the court says correct, and I'm like, that is what I'd hang my hat on appeal on this.
If the transcript caught that, she mumbles.
There were
the
two
hell
people
out of
talking
that.
at
That's
once,
correct.
so it might
Yeah,
be
she
missed.
mumbles the hell out of it. That's correct. She like almost whispers it under her breath, like by people that are larger and higher up than me. Very simple, Judge. I am bound by the appellate courts and their ruling in jurisprudence. I am enforcing that binding on you, the trial attorney. This whole fucking trial, this whole trial has been that. Unprofessional remarks. I know that people have been saying, give grace, and I am to the greatest extent that I can. But when it comes to a criminal trial, your first fucking job is preserving the record.
Especially when
false.
You've got an issue. You've got an issue like this that's literally gonna be looked at from every angle, from every part of the country. This is. It's not the first case in the nation where a parent's been tried for something their kid did, but it's the first time like this. This is a precedent-setting case. Everyone's going to be watching this. Why not have it clean? Why not have a nice, fair fight where we can make a decision?
And it comes down to the attorney too. The attorney has to one of the people in that courtroom has to be an adult, and I haven't seen it at all. So someone's got to grow up and be an adult. I'm sorry. Y'all took the bar exam. Y'all studied long and hard. Y'all took oaths. You did that. Someone's got to grow up and be an adult. So, what a shit show of a trial.
Good thing there was nothing else happening this week in courts across the nation.
Oh, I'm sure.
Man.
I'm sure. Let's see. Let's see if we have any questions, because I want to get to those. Judge needs to have more "don't get brazen with me" energy. Well, that judge didn't make ruling. He just yelled. Less wishy-washy, bumbling. I agree. It needs. Who is the judge? Borofsky. I loved him. He was like, "Nope, not doing it. Moving on." That was in what case was that? Borofsky. That was the dude that was trying to claim self-defense.
Not sure.
Someone's gonna come up with it. I know the chat. I'm giving the chat the second to catch up, because I know Borofsky. One Rittenhouse, Edgecombe trial, the Edgecombe trial. Borofsky was like, "No, move on. You're not doing it. Get out of here. Nope. Next witness. Call your witness. I'm not doing the time." Yeah. question. Can the judge's lack of judgment when asked be an appellate issue? Nope. Not an issue unless you make it an issue. You have to preserve it. Preserve the question. Can they appeal that the judge was incompetent? No, that's not a basis for appeal. Just really not.
Unless the judge makes a mistake. You can't just be like, incompetent.
Yep. New Zealand Butterfly Girl, can you force the judge to make a ruling, and can you appeal based on the judge not making a ruling? You can force the judge to make a ruling, and there's ways to do it. It's very uncomfortable. As a lawyer, you risk like the judge saying, Mr. Morton, do you have your toothbrush? And you say, well, judge, yes, I have it in my briefcase. I always do. But are you going to give me my ruling? Are you saying I can't do something? Because I need you to do that. Tracy Fagan, is the defense attorney too inexperienced? I don't know. I don't know.
She's had some high profile case previously.
I get it. I just don't understand. I don't understand. What is she doing? It seems like the narrative is lost. Like we're in the trees and we're going, where's the forest? Crazy Cat Queen question. What if Ethan got called and pled the fifth? So what? Mistrial. Someone gets in trouble. Judge gets pissed. What? They have to do it all over again. You don't want that. The judge would not allow Ethan Crumbley to take the stand. That's the problem. The judge, at the end of the day, if defense counsel says, I'm putting him on the stand, the judge is going to be like, no, you cannot do that. There you go.
Yeah.
That's the ruling. Yellow Pill. Could only his comments about his mental state be used as present sense impression? Yes. That's that exception. Now there are other exceptions you can try to get stuff in under. I don't think it even qualify in this. Not with the journal. Ian,
They'll get
the
two
thing
of the
is-
three.
I mean, I don't know. I don't know the relevance of he's in emotional distress because we already know that there's some other corollary evidence. Like
what about stuff?
Yeah.
Can we also talk about how no one, Gingy Probs, is 100% in their journal? They're not always accurate or honest. It's an expressive language. That's possible. This journal was pretty bad. Like this journal,
and
this journal
also,
was disturbing.
How often do teenagers complain about their parents?
A lot.
Like,
And they use
they don't
rhetoric.
really understand me. They don't love me. They don't help me. They don't anything. I'm like, I think that's probably approaching 100% of teenagers. I feel like a lot of teenagers would,
But. And then the other part was this: how can they prove JC read this? And that was one of the first questions that defense counsel asked. That's the part where I'm like, I don't understand it. Because you make this argument and you're going, get the point. And then on cross, one of the first questions, there's no evidence to suggest that she saw this, right? It's enraging. It is. JPC, apparently the school did not have a zero tolerance policy. I taught 38 years. Our zero tolerance policy would have suspended him 10 days for simply drawing the gun. The drawing thing, I have a problem with the suspension immediately with that. But I see the point. I do.
10 days for drawing? Huh.
It's a lot. Ginger Probs, how'd that journal even make it in? I don't think it could have. I don't think it should have come in. I think that was the ruling the judge was trying to protect. And that bothered me. Sibling Creature, I get that legally there would be grounds for the search. I don't get how, quote, disturbing homework, end quote, leads to, quote, maybe there's something in the bag we need to see. I can get there pretty quick. Like the homework had apparently a lot of drawings on it that were vulgar. The firearm being used in some of them, I think. So the drawings were a problem. And I think you could have searched based on them. SF in Texas. My son had a teacher. They refused to put any missing assignments on the parent portal until the end of the grading period. It was very frustrating as an active parent. It's the other thing. Like, The school had an issue here too. I don't know if it's criminal, but the school had an issue. Nancy D, I won a litigation.
Litigation.
I won litigation against my daughter's school. They kept pushing her through school. When I went to every PPT meeting, parent teacher conference, I guess, and yep, schools paid for my lawyer. I have a problem with a lot of the way schools are run right now. Amy Z, want to know what schools have no problem searching for? Vape pens.
Hell, there was just a somebody posted to legal advice on on Reddit, which, by the way, don't ever do. It is a wretched hive of scum and villainy. But their complaint is that their school forced a bra check on their daughter to look for a vape pen. And the bra check was, lift your bra out and shake to make sure there's nothing hidden in there.
And
I'm
what?
like, nah, vape pen's a little less of a concern.
I had another thing here. Solo YOLO. If parents weren't the problem, only a 15-year-old child was question. Or underfunded school who didn't have all the knowledge about demons and unsecured gun. My question would be that. I would have actually, if I was defense counsel, I would have asked, how many searches did you have of vape pens? Or how many searches did you execute that year of backpacks? And what were the grounds? On what occasions did the school exercise this authority to search? I think that would have come in. I don't know.
Or kicking a kid out of school for the day.
Yeah.
Making him go home.
Carla Vieira, Harris, and Klebold were on psych meds. People blamed the psych meds.
Yep.
Arla 7247, recovery as a parent. If your child begs you for help, telling you he is hearing voices, what would you do? That's not a fair question. I don't think that's a fair question at all. And not
the
one
standard isn't did you behave, ideally or whatever else. It's, you have to be way beyond way beyond best behavior there. So
I can tell you without going into too much details, we have had kids who have had questions and problems and needed help, and we've sought help, professional help, whether it's medical or therapy, things like that. We're not opposed to that. We see that as an option. I don't want to put my family out there too much because we're different. We homeschool. Okay, we're one of those families that we are the parent teacher conference. It happens right here in our front room. But I would hope I wasn't in this situation, but I think all of us would say the same thing. That it would never be my kid, right?
You'd hope to catch it. Yeah. Sir Frank Otter, thank you. This case is Swiss cheese model. Heart all three of you. Thank you very much. Kelly Bridenbaugh. They said she was a helicopter mom, but everyone thinks of that in different ways. I am one, but my son is verbal autistic. So until recently, I had to be, and there's a difference. There's a lot that you're missing in a lot of this back and forth. People need to give. I don't know. It's tough. Whiskey 77. Ethan has been seen. No mental illness. Behavioral. Jen Decker, my daughter took a bow and arrow to school for show and tell. Oh, God. Okay, thank God she's in an autistic school and is autistic. It's a norm school, instant expulsion. In a norm school, instant expulsion. Yeah. Things are different. Kids and schools is a tough freaking topic. Feral Dragon's son has a personality disorder. We knew at an early age. I had a therapist do in-home ABA, etc. My husband was checked out. I'm currently in a DV shelter, proactively praying my husband wises up soon. Woes up soon.
Wakes up.
Wakes up soon. I'm very sorry. Please seek and maintain that protection for yourself and your family. Please do that. Jeremy Morton, Ian's gap is a good indicator.
That's the gap between obnoxious and criminal.
Yes. Marianne, if he was found to have change in personality because of a brain tumor instead of mental illness, it would have been viewed differently. Both are medical illnesses, yet one is socially, quote, acceptable. We don't do a great job about mental health in any country, really. Melissa P. Rob, what about straw purchases? They're there. The idea that you are ever going to prevent guns from being out and available It just is not going to happen. It's not ever going to happen. Ever. You can ban everything in the world. You're never going to stop. You cannot stop people from creating implements to inflict harm on other people. They're going to create the things. The vehicle comparison is a straw man fallacy. That's okay. That's a fair assessment. You can make that opinion. Don Burke, I was raised with guns.
Even if you think it's fallacious, it wouldn't be a straw man.
Yeah. Don Burke, I was raised with guns. My dad taught me respect for guns. He taught me to shoot. Ian, you were making a point. Sorry.
I mean, you might say you disagree with the analogy and that it's a faulty analogy, but it's not a straw man. It's just a different analogy. I mean, neither is the cheese pizza, you know, like every analogy is different in some way, but I think the cheese pizza is a worse choice for this.
That's pretty bad. Azam. Hey, Rob. All right. My first time seeing you live, Scott. Well, Azam, now you have a new channel to check out. I know that you like watching. I love having you here. Go check out Scott. He's
Welcome,
on all day.
Azam. Good to meet you.
Yep. Lindsay, chat smashed the cookie goal in like 3 minutes. Awesome. Desiree, Rob, and RA, did you know Shannon Smith was the lawyer for Larry Nasser? I did not. She said in one of the documentaries that the number of CP images he had, 37,000, wasn't a high volume of items. Well, that's an opinion, and I don't want to really think about that.
You'd be shocked at the numbers some of these people do reach.
Nancy D. Rob, did you watch Dr. G analyze today on Jennifer? I did not. She showed a lot. Her testimony did not help her, in my opinion. Southern Mom, Crumbly Trial is a tragic situation regardless of the outcome. Shouldn't the fact that Ethan was charged as an adult put all liability on him? Yes and no. I don't know legally. I don't know the case law behind that. So
I don't know that the charging decision actually ends up being relevant there.
I don't think that matters too much. Catherine Frazier, congratulations on 250,000 subscribers. Runkle of the Bailey, you hit 250 this week. Massive milestone while he was sick and incapacitated.
You did it flat on your back in bed.
I'm still sick. I should probably not be here, but I wanted to be here. So,
well, we get to talk about Sarah Boone in a minute.
Oh God.
The Chugi Show. What I got out of this: don't own horses. Don't do ski patrol. Don't doing anything not specifically related to being a parent makes you a bad parent. There was a way to make the point. The prosecutor didn't make it. Carla Vieira, she specializes in sex crimes, very comfortable with that theme. Well, we learned about that. K-Rab, at the beginning, judge said for a sidebar, they would go into the hallway. When defense asked to go to the hallway, judge said no. After that, we got this. Make it uncomfortable. Make the issue. Make the point. Be the pain in the ass. That's your job. You're a lawyer. Make the judge do their job.
Sometimes your job as a lawyer is to get yelled at by the court.
Yeah, a lot of times. It sucks.
And that is just the way it is.
I haven't seen this judge yell at anyone. She's whispered at a few people somewhat sternly, but that's as far as she's gone.
Well, make her start.
Yeah.
Saddle up and get yelled at.
Crazy Cat Queen, serious question. How many parents can say they knew their child was going to murder? Stats. I don't know. Nancy Kane, what happened at the Gundys? Did Runkle win? He did not.
But we had fun.
We had fun, and he lost to someone that we actually were happy to see win.
Yeah. And so that's Washington gun law. And he had his kid there. I was kind of glad to see him win with his kid there to see it. So
it was really cool. And he was a really nice guy.
Yeah, it's like, it's one of those things where it's like, and I didn't think I was going to win anyway. So it's not like I was like invested in that. And so I was like, yeah, I'm glad that he's winning if I can't, right? So yeah, absolutely.
But if you guys wanted to see that Ian and I do clean up nicely.
Well, at least you do.
Don't disparage yourself.
And you promised no Photoshop, right?
No Photoshop. Open.
Just a lot of filters. Yes, I'm seeing a lot of people who are really liking my voice, and it's like the reason why my voice is like this is because my lungs are full of crap and my throat is ripped to crap.
Wow, I'm impressed. I'm speechless actually.
What,
Ian, with
do we actually look like adults?
Wow. I never would have guessed. I never would have guessed that you guys could.
I did have to
pull it
slip
off
that
like
little
this.
pocket square into Ian's coat pocket.
The thing is
Rocking.
I actually do have a pocket square that goes with that tie. I just forgot it.
Those are nice.
Can we?
Are those?
we-
Is it like a set of ties? Do they come together? And you guys, you
No,
chose which one?
no,
No, there was no
it
coordination.
no coordination. But can we
That's
appreciate that
incredible.
Ian has a sword tie clip and I have a
I see a
gun
pen.
clip? So
is
yeah,
cool.
it was a great time. We cleaned up okay. We did okay.
I believe it was Marmar who sent me the sword tie clip. It is amazing, and I hope I haven't lost it. I got to make sure I've not lost. Oh God, I got to check.
Carla Vieira, if school shootings were caused by parental neglect, most would have happened to Gen X latchkey kids. That's an opinion. Arla 7247, what about the child saying, help me? The child needs to be on the stand to say that. I that's the point. Like that, you cannot get that in via a journal.
And the
It is
number of
too
kids who have
prejudicial.
said that and not done anything like this, like, it's not actually a strong indicator.
Yeah. Dr. Bullbutter, I'm tired of people arguing for the parents. I'm not arguing for anybody. I'm arguing for the appropriate application of law. Just so tired. I'm a substitute teacher with a disability. I would have died that day. I would have hoped that that day would have never come, and that the safeguards that were in place and appropriately utilized by the school, staff, authorities, parents, all of them worked appropriately.
Well, and you know who
I am
else
not
might have
advocating for anybody. I am saying that the application of law needs to be fair.
And you know who else might have a duty of care? The teachers. So do we think that people at the school should be convicted?
I don't know.
Because I mean, could also be in that cell.
Well, and they tried in Florida. They tried with the school resource officer. Charged them.
So I mean, they're not going to stop with the parents either. So if you're a teacher, this should scare you in more than one way.
It scares a lot of people. It scares a lot of people for a lot of reasons. Like the entire concept is scary. And honestly, I stayed away from this trial because I
stayed away from it because I had the flu and I wanted to do daily recaps and I couldn't.
I get scared. Mini Mischief goes to an elementary school and I don't like any of this stuff. It's very difficult from all angles. So Lynn Britton, I never said my kid would never. He did. We dealt. Chris Cat Queen, 2021 stats, 2,590 with guns versus 42,939 with motor vehicles. In Fairfax Juvenile Court, there is a big poster board with a map of Fairfax County, and on the poster board are pins where every teenager fatality vehicle incident occurs, and they keep updating it. They keep putting the pins in. And at the end of the year, it is not something you ever want to see. I will tell you that. Equality. I used to be a perfect mom before I gave birth. Sorry, Ian.
There is an important safety tip for your teenagers, which is keep them out of gangs. So that is a big factor. It's a huge sort of risk element there.
Yeah.
So
Solo YOLO 1853 is the first recorded USA school shooting. I did not know that. I learned that today. Apple Silver, it takes no skill to put a child in prison. Doesn't. Jamie Lee Quickert, I am from Oxford and my dear friends with one of the victim's parents. My friend's daughter didn't die, but she was the first one shot coming out of the bathroom. I was in the courtroom. I'm very sorry that you had to go through that and experience what you did in that courtroom and relive a lot of that. That must have been indescribable. And I'm not finding fault on any parent of any child or anyone who wants someone to be held accountable. You are allowed to have that feeling 1000%, and I am not discrediting that. I am here trying to explain the law as it exists and to say how it should be applied in a case that is this complex. It's not easy. It's really fucking hard. And this case sucks. And I'm sorry that you have had to go through any of this. I never, ever want anyone to ever experience what you went through or what any of these parents did. So please don't take my commentary for being dismissive of the victims or anything in this case. This case sucks. Allegian News. When Crumbley case, could we charge Murdoch with another murder for his kid's boat accident? They charged the store that sold the liquor. Civilly, they did. Allegian News, Michigan, you get driver's ed at 14.5 years, permit at 15. Mama bets if it was civil instead, would opinions be the same? Oh no, civil, they're all liable. Everyone.
That
I mean,
lower
civil
threshold has
standard
been
is-
met.
Yeah.
Oh yeah, you're there all day. Civil all day, you got it. Clean sweep, you got it. Civil, every one of them. Silence. The entire case gives me anxiety. It does. Jules, started against the parents. Now I'm on the fence. This isn't on the fence. You can feel that way. Love you all. Hi, Rob, Scott, and Ian. Great way to spend a Friday night. Thank you for being here. Sibling creature. Could this refusal to make a ruling be appealable? Nope. Kadeta Smith. Yay. 3 months high to the best 3 amazing people. Love all 3 of you. Thank you very much. Very kind words. AG, what is your opinion on defense counsel's whining in front of the jury? It seems worthy of such on its own of merits. Why is this judge so evasive? Scott?
The defense counsel whinging is unforgivable.
Well, Scott?
There's a distinct tone that seems slightly piercing in her voice, and it grates on a lot of people. And I'm giving her space because I think she's a good attorney. I think she's fighting hard for her client with a crap deck. Okay, she's playing poker with 3 cards and it's 5-card stud. I think she's fighting hard.
I disagree that she's using a bad deck. I think she's got a lot in her favor. And I think some of the arguments she's not making that she should make. I think also that sometimes she does really well. Like there's times where if I just tuned in to her dealing with a particular witness, I would walk away and be like, thank God she's got a hotshot lawyer. She's got a crackerjack in there.
Parts
It's
of her
awesome.
Parts of her closing were absolutely amazing. Just
Parts
like,
of her closing were brilliant.
That's what we want.
And parts of her closing were god awful. And I'm like, how is the same lawyer hitting the 2 extremes here? I watched her cross-examine the one of the school individuals, and I walked away going, every question was a focused question. She was getting the answer she wanted. She had perfect control of the witness. She got everything she needed. She left that witness in shambles. She walked away with better from that witness than the prosecution got. Like she took the prosecution's witness and turned them into her own witness. And I was like, that was excellent. And then on another day, she's saying in front of the jury, I'm going to kill myself in this trial.
I'll give her this. I'll say she has. I thought when she started that this was an act. Okay. And I said several times that her performance in the courtroom, this is an act. This is theater. This is a stage. She's doing there's so much stuff. I'm just so scatterbrained. I don't believe that anymore. I think that's actually her. She needs co-counsel. She bit off a huge case with tons of data, and she can't do it all herself, and that's why she's letting things slip. She's not making the objections that she should be. Oftentimes, I think I mean, if I can tell it's a leading question, and I'm not a lawyer, okay, I think she should probably be saying objection leading, and she got
Yeah.
that occasionally. And then the judge would rule on it, and he would say, "Okay, all right," and then he would ask a leading question to follow up after the objection was sustained, and there was no objection. And so I realized she could have done it much better. But I think the whinging, I think that's what the word is, the whinging or whining, is part of that was from the fact that she was overwhelmed.
During the closing, when she's going like, because she said like 3 or 4 times, you know, she's like letting the jury know that they're making fun of her on TikTok.
That was me. Sorry. I owe her an apology. I had a sorry, not sorry counter running in the bottom corner of my screen throughout the trial. And
The
I'm on
thing
YouTube,
is,
not TikTok, but sorry.
You're going to get made fun of on TikTok if you're doing a national trial, right? It doesn't matter how brilliant you are. Somebody out there is going to, you know, like the Maya trial, there were TikToks making fun of the lawyers on both sides. You just stay the hell off of TikTok. You know, you don't, or you develop a thinner or thicker skin, or you talk about it with your spouse, your therapist, literally anybody but the jury who is supposed to have been sequestered or at least not seeing the TikToks. So the one thing you don't want to tell the jury is the people at home who are watching this are making fun of me. Like, that is something you should never tell the jury.
It was an
And
interesting strategy for sure.
You also don't whine about it. Like, just if you want to make a, like, and people say, oh, you can, like, she was humanizing herself with a joke. She could say something like, you know, and I'm sure there's people online who will be, you know, like saying nasty things. You don't have to like me at the, because that was the point she was making, is like, you shouldn't rule against my client if you don't like my client or if you don't like me. She's like, you know, she could say that without actively communicating that she's upset that she's being made fun of online.
Wasn't she just trying to get the jury to hate her more than her client, so that she was the bad one in the room and they could, you know, not throw the book?
There's a way of doing that. There's a way of doing that doesn't involve this.
And sometimes the way to do that is to just like actively wear the horns. Like, you know, I know you don't like me, and I'm going to tell you that's going to continue because I'm here arguing for, you know, for the accused, and that is always a difficult place. But, and you can be the dislikable person, but you never want to be pathetic. And whining about being disliked in front of the jury is pathetic, but it also communicates that you're disliked. Like, the jury at this point shouldn't be seeing any public anything about this. And you want the jury to be ruling on this trial solely based on the trial. But one thing jurors consider in the back of their head is they think, when I go and tell people that I was a juror on this trial, are they going to hate me? Like, are people going to think I did the right thing in ruling for or against? And if you communicate to the jury, the public at large thinks I am a clown, then the jury is going to think, well, then we better convict your client then. Like, don't tell the jury to convict your client.
Here's what everybody out in the world that you don't know about is thinking about this case.
Yeah, don't hint that your client should get convicted in the eyes of the public watching at home. So, I hated that so much, and it made me so angry because it was so unnecessary, and it's just her hurt feelings. If she kept her abilities at the top level of what she was doing, she would have been excellent. Like, fantastic. And it was just the variability.
Yeah.
Like, there was another moment that I thought was just shockingly, unforgivingly bad. The videos were rolled day one. And she says, you know, and the prosecution objects because, like, defense counsel is sobbing. And she goes, of course I'm sobbing. It's, it's terrible. And I'm like, the jury can hear you. Because I don't remember if they took the jury out of the room, but they noted that the walls are paper thin and she's just shouting all of this. And I'm going, you don't say that. You got to have a poker face. And she's like, they've watched this 50 times. And the judge is like, so have you, right?
And she goes, I've never seen it.
I've never seen it. And the judge is like,
shit.
That was the double bird incident. Did you see that?
The thing is I believe her there because the judge says, oh, well, you've had it for this long. She says, no, I didn't. It's at their office. And they're like, well, you saw it. She's like, I didn't watch it because it's not relevant and it's terrible. And I'm like, I believe you that you didn't watch it, but holy fuck, you should have. And you watch that until you stop flinching. And I know that is one of the shittiest things about this job, because sometimes you'll have to look at things and just until it's like, okay, this horrible picture of a guy whose head was dragged across concrete, I can now talk about this without like making the ick face, because you need to be able to do that to represent your client. If she, like, the judge actually made a what the face when she said that, and you don't want the judge making a what the fuck face about you not having reviewed the evidence
that you've had for years. Yeah.
Okay, Ian, you need to pause for 2 minutes. I have to get through super chats, and there's a lot
Sorry,
of questions.
I'll try to restrain the rants.
A lot of questions for Scott, and Scott does not usually stay up this late.
I'm
This is
way past
our
my
hour
bedtime
of
already.
the night. Tracy Collins, this is the epitome of Monday morning quarterbacking, but with the worst consequences. RA, please tell me you've searched your old texts with Mrs. RA for out of context messages.
How soon can I plead the fifth? I'm just curious. Asking for a friend.
The
Asking
best time
for a
is
friend.
now.
Yeah. I love this one. Put your toothbrush on the table and call Ethan. Yep. Grab the bag, toothbrush, table. We call Ethan Crumbley. I mean, that's one. Peggy Reardon, I assessed sex offenders for 20 years and 37,000 photos is minuscule compared to what most offenders have. More like 370,000. My God.
And the
That
thing is for
scary.
a lot of them, they may not have even seen a lot of them. They'll trade packages, but some of them have like literal terabytes of content.
Yeah, like separate hard drives. Yeah.
Yeah, and like every time one of those hard drives goes into a fire, the world becomes a slightly better place.
Slightly, yes. Tiffany Zabranik, can we get the defense closing before you totally lose it? We have totally lost it. What I will tell you is if you want the defense closing, please go check it out on Scott's channel. He covered every day of this trial, gavel to gavel. Please go check out Scott's channel, Recovery Addict. He's been covering this case, and he covers cases all day, every day. That's what he loves doing. So please check it out there. You can catch all of it there. If the transcriptionist is worth a dang, they caught it. We could hear it on tape. We have software that helps catch mumbling. I use it every day. Thank you for the tip. Phenomenal. Kristen M96. Wait, is that the Angel bot in the background? Yes, it is. That's the Angel bot sitting there. Hang on. New bot, Angel bot. That was from Kristen. If so, did the Snowbot make it? Did he melt? Snowbot made it. MEZ, but now the cheese pizza analogy from Shannon Smith makes so much sense. Damn.
The thing is, it makes sense because you do end up with parents who have kids who send pictures of themselves and so forth. And I can see why it would leap to the mind of the lawyer because she deals with a lot of those files.
Yep.
The jurors mostly don't and are mostly horrified by that kind of discussion. So,
Mary Ann, how tall is Ian? We're all shocked by the pick. Ian is about 4 inches shorter than me.
My height varies by about 2 inches, depending on how bad my back is.
You're between what, 5'9" and 5'10"?
5'10" on a good day.
Yeah.
So,
Susan, while talking about guns, I'll be taking a safety gun course next weekend. One, great idea. Thank you for doing that. Any tips? Listen.
Yeah.
Listen.
Listen at your course and don't point the gun at any, like, gun is always loaded. Don't point it at anything you don't want to destroy. Keep your finger off the trigger. And, you
Can I
know,
share a quick story?
yeah.
The last gun class I went to, because I for a while had concealed carry license, and I went to a gun class. The teacher who taught this class a million times. He brings firearms for examples for people to look at, and they've gone through. I mean, like double check, triple checked everything. And as soon as there's a break, people can go up and look at the handguns. And I look at one and I say to him, "Can I pick up that? You've got a car 9mm, a gun that I was interested in." And I picked it up. The first thing I did was rack the slide back, and it was loaded, locked and loaded. One in the chamber, just sitting there in the training class.
Oh, God.
There should not have been ammunition anywhere near that room. So just always treat a gun as if it's loaded, because
Always.
you might in your head you might think it's not, but so many
And
people
if
have been
you
shot by
put it
unloaded
down-
guns. It's not.
If you put it down and walk away, when you come back to it,
It's
pick it up,
loaded.
check it again.
Yeah.
Pick it up, check it again. The second that thing is even, I have checked a gun in my hand when it has been in my hand for the last 10 minutes of conversation, and I will check it again. Like
Every time I'm sort of handling a gun, if it's not meant to be loaded, I'm checking it. And I remember one time I'm packing up my guns to take home. And there's one I'm like, I've just checked this. I'm sure I just checked it, but I'm going to check it again. Cartridge pops out and I'm like, well, I guess I didn't. And
I've got two friends that had to patch walls because bullet holes from an unloaded gun.
oh my God, that is terrifying.
And one was inches from his brother. And I mean, a shotgun blast through a wall just inches from somebody. It's just, you can never be too careful.
I know an instructor who has a broken gun that he loves using for safety instruction because the ejector's broken. And so he'll throw in a snap cap in that, which is, a fake cartridge. And he'll basically show people, he's like, I want you to tell me what I'm doing wrong, or if I'm doing this, if I'm unloading it properly. Drops the mag, racks the slide like 15 times and says, have I unloaded this gun? And people go, yeah, I have. And then he pulls the slide back, locks it back, and pulls out the snap cap and says, no, I did not visually inspect this. You've got to, don't assume your gun works in, all of these things. Don't assume your safety works. Don't assume your your extractor works. Don't assume any of that.
But to be honest, that's why I think Baldwin's defense fails. Baldwin's defense fails because he places too much reliability on external things. I don't know. That's my opinion.
I would recommend that gun class, a safety class, even if you don't want a firearm. I think
absolutely.
It's not the last thing you do before you buy one.
Well, and there was a case about a year and a half ago down the street. There was an incident report where there was a firearm that was found in the gutter, like literally right down.
Yeah.
And the person that found it didn't know what to do. They called the cops. They just called the cops. One, good call, but they didn't know what to do. And imagine if someone walks upon that, doesn't know what to do, doesn't know how to handle it, doesn't know how to what it does, and just leaves it there. You have to know how to responsibly handle these things. I think it's important for everyone to know this. So, Corwin Feldstrom, hey Ian, what's your take on the NB family law thing? I don't know what that is.
I don't know what that is either. So, I'm happy for you, or sorry that happened. I'm not sure which story you're talking about, I'm afraid.
Shelby Taylor, Rob, would you have called anyone as a character witness for Jennifer mistake? ? I wouldn't have called anyone as character witness. I don't want to get into character. I don't.
Character is normally inadmissible. If you bring character into question, then the prosecution gets to. And the first thing the prosecution is going to do is they're going to say, I want a ruling that character is an issue. And the judge has been giving the prosecution rulings. Like, oh yeah, we are ruling that now these text messages can be looked at and that kind of thing. And then they say, we need another 5 days of trial. Because now they're going to bring in everyone you ever did wrong.
Everything. When the prosecution has the chance to spike the football, I have never in my entire career not seen a prosecutor spike the football. Ever.
it's just there's going to be somebody you owe money to, some ex that it ended badly with, who's going to come out and say, oh yeah, they're a terrible parent, they're, whatever else. It's don't ever it's rare that you're going to find the client who is sainted enough that you want to put character at issue. I wouldn't want to put character at issue for myself, and I think I'm a pretty decent guy. So, yeah.
You're okay. We'll keep you around. Morgan 908. I'm a project manager. From now on, I shall whisper sternly at underperforming team members and absent project sponsors. Jen B. Thank you, RA, for giving us full coverage so we can form opinions. Thank you, Rob and Ian, for explaining all the intricacies of the law. I freaking love anytime I can talk to Scott about this, because he's watching the stuff day in and day out, and his questions are sometimes the most informative questions, and they're the best questions because he watches it. So I'm happy to have him here and happy to see him joining us this evening, even though it's late for him.
Very late.
Canonical Heat. If my husband and I eat those tag-alongs at Samoa's, I'll be blaming you, Rob. Fine, I'll take the blame. Kyrie, what a great panel. Thank you very much. JP, prosecution argues that Crumbley parents bought a gun for their mentally ill son, but fought and proved he had no mental illness at his trial. I didn't see that, but okay.
That was at his trial. They fought against an insanity defense.
Yes, they did. Insanity and mental illness, very different things. So
yes, you can be riddled with mental illnesses and not insane for the purposes of the court.
Yeah. What was the decapitating woman? Who was that?
I don't remember.
Is that Shabusiness?
Yeah, Shabusiness. Example, Shabusiness. It's Bree. Some don't know how for that convo. Easier to ignore. Please don't. Talk to your kids. Really do. Dune, fear is the mind killer. It is. Angie, high school was a while ago for me, but backpack searches were a regular thing at my high school. Usually the excuse to search us was that they were looking for markers used for graffiti. They make up a lot of stuff. Colby, why do you think they didn't charge lesser charges? They wanted this one bad. They did. They really did. Matilda, hello from the Netherlands. Hello to you. Dr. Bullbutter, I pray for healing for the victims. I do as well.
Yeah.
Katrina Turner, I grew up a U.S. Army brat in Europe in the 80s. Active terrorist drills were routine from age 11 to 17. It breaks my heart that our children are now doing them. That is a thing. And the school doesn't tell you when they're going to drill the kids, like when they're going to have the active shooter drills. It's, I'm glad they do it. It's tough. Peggy Reardon, I think SS was used to having her partner with her on cases. They split after taking on these parents, maybe overwhelmed being alone. I don't know. It's possible.
And it could be that she was picking up, because if she had a partner and she was splitting the labor, it could be she's struggling to fill in the gaps, of what the other person was supposed to be doing. So,
yeah. Tiffany, panel, when the defense rested abruptly, was this intentional to catch the state off guard? Thoughts?
I'd say yes. They played this game. They played this game throughout the whole thing. The defense was like, Your Honor, they're not telling us who's coming next. I need to know who it is. I have to repair. And they're like, we gave you our whole list yesterday. It's 9 people. Yeah, but I need to know who the next people are. Back and forth. As soon as the shoe flipped, they were the exact same argument. She needs to tell us who she's going to call. We need to know. We've got to prepare. We need time. It's just the courtroom. We've seen it in a million trials. And I think it was just strategy to try to throw him off and catch him off guard. But the judge gave him a huge an hour to prepare. Anyway, so it didn't
interesting. Tiffany, again, Rob, I spend my days with RA. Much love, but I want your opinion on the closing. I haven't watched it.
I think that was a while ago. Oh, you haven't watched the closing?
No. And honestly, I don't have time to do that this evening. What I will tell you, Tiffany, is I will watch that closing argument, and I promise you the next time I am live, I will give an opinion on that.
Well, I know somebody who will probably be talking about it quite a bit on Monday.
You'll hear it.
Runkle of the Bailey. Go check out my friend's channel on Monday. He does a Monday night show. I'll be on with him on Monday. And if you have a question about the closing, I'll listen to it over the weekend and I'll give you that opinion on Monday. I promise you that. Okay, Tiffany, I promise you. Gabrielle, thank you very much. Elise, Charlene Fine Art. Did you see Captain Corey's mom's video? I did not. I'll have to check that out after the show. Please send all our love if you speak with her.
I got to reach out to her, I think.
I'll check that out after the show. That makes me a little concerned. Gingy Probs, gentle reminder that things like the sound of one's voice, whiny, whispery, is the sort of thing women have battled for years. Trial strategy, yes. The person, it gives me pause. Thanks, y'all. I don't buy into the whole like how they sound. I want to listen to what they're saying. So that's where I was focused. Janet Burris, best advice for my firearm safety class: the gun is technology and guaranteed to fail. Yes.
The thing is, all of the gun rules are designed so that if you screw up any one rule, you're not going to kill anybody. It's got to be 2 or more.
Yep. You need
and
multiple failures.
If the gun itself fails and you are following the safety rules, nobody should die.
Correct. It discharges in a safe direction and a safe place where no one is injured.
And I can tell you, I've had a negligent firearm discharge. I had my finger on the trigger when I shouldn't have, and I had a hiccup. And it just made my trigger finger pull, and the gun went off, and I was like, holy shit.
That's a feeling you'll never forget.
No.
The good news is that I was pointed down range, and that shot went right into the berm, like at the range. Perfectly safe. Nobody dead, nobody anything, but it was like, right, finger off of trigger. But because I was still following the gun pointed only in a safe direction, everything is fine. Now, if I was doing that and the gun was pointed casually into the air, problem, so yeah.
Other advice. I just thought of this because I remember this experience. When your gun jams, which it might, it really might, and it will.
Do not look down the barrel.
When your gun jams, 1, place it on the table, barrel facing downrange. And if you're not familiar with clearing a jam, raise your hand and ask for someone to come help you. 2, if you are clearing the jam, remember where that barrel is facing.
Yep.
Keep it pointed downrange. The clearing of a jam is one of the riskiest things. Like that's one of the things where if you have your hand near the trigger or if you're clearing, and depending on the gun you have, that can be very dangerous in that moment. So raise your hand. Someone's going to come help you. I guarantee you.
And if there's nobody to help you, like
walk away.
I mean, you can't probably leave the gun at the range or anything like that.
You
but
know what I mean.
You got to be careful. You got to keep in mind that you are at that point basically dealing with a bomb.
That's where the classes come in. Before they'll teach you what happens when you get a squib load and potential for a bullet to be lodged in the barrel, even though it fired and ejected a cartridge. And
well, you also get things like in Canada, we have this thing called winter, and winter gets really cold, like to a degree that the kind of gun you use in the cold, like it's a consideration. The Canadian Armed Forces, up until recently in the Arctic, used the Lee Enfield. And if you're wondering, hey, what is the Lee Enfield? Well, it's a gun that was used in like World War I. Why did they keep using the Lee Enfield? Because it works great in the cold. And what doesn't work great in the cold? Lots of modern guns, because they're built to tight tolerances. And if you've got tight tolerances, you can get the metal freezing on metal, which can lead to one of the worst possible states, which is you're shooting in the cold, you pull the trigger, and nothing happens, and then you try to work the action, and everything is frozen solid. Because if you're really unlucky, you might just have had the gun in a state where the trigger has been pulled, that hammer is like the firing pin's ready to do the business, released. And the only thing stopping it is that metal is binding to metal in cold,
and the warmth of your hands changes the temperature of the gun as you're trying to
Or
feed.
what ends up happening is people take that thing, they say, I don't know what's wrong with this gun. They throw it in the trunk of their car.
No.
And then on the drive home, they got the heater going because it's cold out. And then suddenly there's a hole in the side of their car. And so, you know, be aware of these things and know what your plan is if this happens.
Like, just be smart. Like the other thing the prosecutor did in this case that drove me nuts. Actually, hang on. Let me finish these real quick. Sue Kendall. Sorry, off topic. Wondering if Ian can recommend a Canadian online therapy group looking for a North American therapist who speaks French.
That I'm afraid I don't know of an online one. And most of the therapy groups I do know of are from like work. And so they're not really aimed at the average bear. So like if you need anger management because you stabbed somebody, I can connect you to somebody here in Alberta, but
well, and Sue, I'm going to ask you to look at the chat because the chat might have recommendations. So look at the chat. The chat might have people. So
yes,
just saying that. Ash, ugly case, but 3 faves on the screen. Bit of joy. Thank you. I agree. AG, can someone? Oh wait, I want to cover this one topic first. The prosecutor in this case did what prosecutors in every case do. When it's a firearm in question, either the bullet is always the wrong bullet or the gun is always the wrong gun. They tried to make the argument that the 9mm was they knew it was more powerful than the 22 handguns they had.
Can I rant about the ATF officer?
Can I give you just let me finish this one point.
I'll put a pending rant.
Pending rant
flag.
incoming. Got it. I have a 9mm. And
just one?
It's Glock.
Rookie numbers.
Glock 19, and I practice with it, and it's a great firearm. It's my household defender, right? It's a 9mm because ammo is really easy to acquire at 9mm. It's one of the most replicated and readily made firearms. Plus, Glocks, generally speaking, pretty low maintenance. Not a whole lot goes wrong. The mechanics behind it, pretty simple. There's not a whole lot you screw up. Thank you. Idiot proof. I love it. It's a great
Glocks
firearm.
are the gun that if you go to an outdoor range and if you were to successfully dig a Glock out of the
you could still shoot it.
Outdoor toilet and it had been sitting there for like 6 months, you could expect that if you put a mag in that Glock, it would probably fire and just work just fine.
Which is why Glocks have been chosen by law enforcement for so long.
Don't go digging in the outdoor toilet at your range, though. You will not, you'll find lots of things, but very few of them will be a Glock.
Thank you, Ian, for the solid advice, as always. Anyways, so that Glock 9mm, I love. I have shot it, but my very dear friend, neighbor, has an FN57.
Ooh, I love those.
Oh my God.
It doesn't shoot
22. Yeah, it's 22.
It's not a 5.7?
22 NATO. Hang on.
It should be shooting 5.7 by 28. That's literally what it's named for.
Okay, 5.7, 28. It's 28. 28, 9mm.
It's just 5.7. It's people just call it 5.7.
Yes, but I have shot that and smaller caliber. Am I wrong? Am I right? It's smaller caliber. I've seen him load it.
It's smaller caliber, but it's a faster bullet.
Faster.
And it's favored by some law enforcement because it's
armor piercing.
It tends to be pretty good against soft armor.
As in Secret Service uses that.
Yep.
That's the Secret Service firearm. So the prosecutor is saying a 22 is, you bought the 9, which is more powerful. Every firearm, every ammunition has a different fucking purpose. If you use, and the reason I make this comment is I go to the range and I shoot my Glock and I've got great muzzle control. Like it's easy to handle. No problem. Not a big kick. I put that FN57 in my hand. That thing bucks. I was shocked.
It's a spicy round.
It bucks. a
I
prosecutor say that like my 9mm is more powerful than something like the FN57 is just ridiculous on its face. But
I want a
every
P90.
prosecutor does this all the time.
So, for those that aren't familiar with the FN 57 you're talking about, the bullet it shoots looks like a mini rifle cartridge, meaning the
Oh, it
cartridge
does.
is necked down to, so the cartridge is big, it holds a large powder charge, and then it gets narrower, and the actual projectile that fires is small. So it's a big powder behind a light bullet,
Yeah,
Yeah.
like a lance. Like
and it looks really cool in a pistol too. I mean, you don't expect a neck down bullet like that.
No, but when you fire it, it lets you know, like real quick. That's not there to play around. But I hate
They're
when prosecutors
great in
do
a
this.
submachine gun, though.
But prosecutors do this. If you have a hollow point, they're like, you use a hollow point because it does more damage. No, I use a hollow point because I don't want it going through walls.
Well, and if you use a hollow point, it would do more damage. If you use non-hollow point,
FMJ.
they're going to say that's what the military uses, isn't it? You can't win this one. If you use any sort of specialty ammunition, it's, oh, well, that's some, like custom. I've seen them argue that wad cutter ammunition was designed to cause more damage. And wad cutter ammunition has sort of a flat nose. It is designed to cut very clean holes in paper for scoring purposes at target shooting. That's what wad cutter is for. And I've seen prosecutors argue that, and it's like, you can't win the ammo game.
No, you can't. Anything you choose is going to be bad. And it's just, you guys, this isn't pro-gun, anti-gun. This is just knowledge. Is it that bad to learn things? Is it really that bad? Anyone who complains about it, it's really not that bad. Come on. This is a good question, though. AG, what a good question to end this topic on. Can someone sum up how the heck a parent could be charged for a kid's crime? It feels like guilt by association and like a dangerous precedent. So here's the thing. Dram shop laws is probably the best way to explain this, don't you think?
That's a pretty good. Yeah, no, that's a pretty good way to go.
Dram shop laws. If I am an alcohol salesperson, if I sell alcohol, I have a certain amount of responsibility because what I am selling is a intoxicant. It's something that can and will cause the intoxication of the person consuming it. And therefore, there's a certain amount of responsibility that I take in selling that product. I'll make the equation in a second. I'll bring it down to this level in a second. If someone's at my bar and they frequent my bar and they come in visibly intoxicated, like beyond all reproach, they're about to fall out of a chair, and I continue to sell them booze, recognizing the level of intoxication they have. If they go and get in their car, I might be held responsible for what they did, driving away from that spot.
Or if they stagger out of your bar, stagger into a snowbank and freeze to death.
Freeze to death, I might be responsible for their death.
Yeah.
So that is me handling something that I know to be an intoxicant, something that will cause that. And I'm handling it recklessly, which means I have an absolute disregard, a willful or negligent, a reckless disregard for the lethality of what I'm doing. Apply that to a child. And the standard gets very high, but you can get there. Let's say that you have a child that will apply this case, but 10 times worse. Let's say that there was evidence, hard, cold facts that Jennifer Crumbley saw every one of those homework assignments and knew and saw the inside of that journal, left, right, and center, knew all of it. And
or let's go, like the child says, I want to kill people.
Yes.
Can I have a gun? And mom says, okay, sure.
But then explains like, oh, but he's probably just kidding.
Yeah. Or, I mean, let's say the kid had taken the gun to school several times.
Yep.
And you just keep doing nothing about it. Right. So that might be a thing.
That's to get you to the pretty clearly. Now you have criminal liability. Like pretty clearly, if the child comes to me and says, I want to shoot up a school, and I say, here's a gun. Now, I don't know they're going to do it, but me giving the child to school that gun after they told me that I'm going to do this. And if you have the evidence to support all those things, that's when you get to a point where the parent is acting in reckless disregard for human life with a reasonable apprehension and understanding that the child or the person that they are giving that firearm to is going to carry out the thing. It's a very high burden.
And the thing is that this could also apply to anyone else who has a duty of care with respect to the child. So lots of people have a duty of care with respect to children.
Yes.
So there's all sorts of, like, the liability doesn't stop and end cleanly at any one point. So be careful there, right?
Please do.
Yeah.
Cynthia Kramer, Rob Pixie is in a mental health facility, wishing her all the love. I will check out her video. I will reach out to her. I will try to contact her. I really will. I'm concerned to see that, but I'll check it out. Mama Betts, please let Hogue know that he saved a life. Ryan Man YYC. Yeah, Ryan Man YYC posted he had a stroke, but got help in time because of Rick. Do you have any idea how much that's going to mean to him? Like,
oh, it's going to
share his stroke story. My prayers go out to Ryan Man YYC and hopefully a very swift and fast recovery. And I am very thankful that he was able to catch that. Forensics 805. Thanks, guys, for all the warning perspective. Thank you very much, Forensics. Okay, that catches us up on this topic. Scott, it is your witching hour.
It is. I turned into a pumpkin in like 4 minutes.
Yeah, I know.
As much as I want to stick around for Sarah Boone, which is just amazing, and everything that happened with the Murdaugh as well, I'm going to catch this one while I'm horizontal in bed, like holding my phone. I'll probably drop my phone on my face sometime tonight, and so if I chat something weird, and it's because it fell on my face.
Or if you have like a weird bruise on
Monday morning, I forgot like a weird iPhone impression. That's it.
My wife tells me to put the toilet paper on the right way, and I don't listen. Don't listen.
I should have learned. Ian, Rob, it's awesome hanging out with you. Thank you very much for the invite. It's wonderful. Love being on FNF, and have a good one. Cheers to you. Thanks to the mods. Amazing. Love my first time on. Appreciate it.
Thank you, guys. Thank you, Scott.
We'll
Much love. Please go check out Scott's channel. Like, honestly, like the dude's one of the coolest people that's out there, and honestly does a great freaking job handling these trials. Amazing job. Like, the people that make jokes of it, make light of it, laugh about it. Scott plays it fair and simple, right down the middle. I love it. So what a great guy. So, okay. Ian, Swoop, and then Sarah Boone. Ready? By the way, we are 3 hours in one topic, so double swoop. Which means
also that means we can swear. So fuck.
There's no chance we get the Murdaugh. I can't do Courthouse Becky. I can't. Not that's like a 3 hour topic by itself. I knew I was biting off a lot with this like round.
I'm not going to cover Boone on Monday, but I will talk about Murdaugh. So
fair. Okay, thank you. We can talk about it Monday, but I do want to cover Boone. Because Boone is just this one's a lot. Let me see, which one do I have up? So, Frank. Okay, here we go. All right, so this is the document that was filed in August of 2023. So taking you back in time. So first of all, who is Sarah Boone? Sarah Boone is the individual who said, I was playing hide and seek with my significant other, and he hid in a suitcase. And then she proceeded to go to bed, came back down. He was not responsive. She claimed she administered CPR. The statements are inconsistent. And he eventually died. Not a great case. She's a character.
Now, I just have to say, have you seen No Country for Old Men?
I love that movie.
What's the most you've ever lost on a coin toss? Well, this is the equivalent of what's the most you've ever lost on a game of hide and go seek.
This is bad. It's really bad. Vices I see in my friend Sarah. Yeah, from inside the suitcase. It's a lot. It's a lot. But Sarah Boone, well, she has opinions. A lot of them. And she deserves to have counsel appointed and deserves the right to counsel and deserves her day in court. That trial date has been continued several times. The first 3 attorneys she had to withdraw because of conflicts, and the trial keeps getting continued, and she keeps writing letters to the court. The letters get more and more inflammatory. The case against her looks remarkably strong. And we honestly just want this thing to go to trial. She deserves a trial. It needs to go to trial.
Yep.
So I'm backtracking to August of 2023 when attorney number 6 filed this motion to withdraw. We covered this at the time. Motion to withdraw as counsel. August 22nd, 2023. I'm not going to say it. Frank Bankowitz hereby request the court enter an order permitting court-appointed counsel to withdraw from this case and from further representation of defendant. In support of such motion, the undersigned states to the court as follows. On or about July 11th of 2022, the undersigned was court-appointed to represent the defendant in the above-styled case.
Now, from what I understand, the court-appointed lawyer has no choice. They just get appointed, correct?
Correct.
Now, chat, if you've never been a criminal defense lawyer, there's a special feeling that comes onto your body when you are appointed to be like the 5th lawyer or like 4th or more lawyer for an accused.
Oh yeah.
And that feeling is fuck.
Yeah. Everything
Why?
about you is uncomfortable. You don't like it. You hate it. You'd want it to be anything other than where you are.
Yeah.
Yeah.
You'd know it's going to be a shit show.
Yeah.
So
due to the irreconcilable differences which have arisen between the undersigned and his client, the undersigned will be unable to effectively and properly continue representing the defendant herein. Please let me out. The defendant will not be satisfied with any attorney unless said attorney does not have a caseload and can dedicate his or her time solely to Ms. Boone's case. Now, you and I had some very strong opinions about this particular sentence.
yeah, don't put that in.
Yeah, like never, ever, 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 ever.
Even getting off the record, like even applying to withdraw, you still have ethical obligations to your client. You have ethical obligations to your client even after they're not your client anymore. So, like, your client fires you, you still have an ethical obligation not to tank their interests. And this is throwing the client under the bus. This is snarking the client. Don't do it.
Yeah. It's you cannot allow the prosecution to have insight into that relationship.
Yeah.
Obligation. You have to keep that communication and that channel sacred. End of story. The undersigned has been in murder trials over the past 60 days and is presently defending a capital murder case in Lake County, Florida, which absorbs all of his time, including weekends. See, that you put in. You can eliminate paragraph 3 and leave paragraph 4 in.
Yeah, you can say I'm too freaking busy. You could even say, like, there's a way to phrase 3 that doesn't throw the client under the bus and doesn't reveal anything. Yeah. You can say, given that the demands of this case, which are anticipated to be very high, cannot be reconciled with the capital murder case, that I was assigned to beforehand. That one says, I'm too busy. This case is going to be a lot of work. But it doesn't say it's going to be a lot of work because this particular individual needs me to be on the phone every 10 minutes or else they throw a wobbly.
Well, and then you've got, hang on, why did I do that? Make that go away. I don't care.
No, you're
then
correct
you've
to,
got
to highlight that.
this one. The best possible avenue is to have the defendant represent herself, as no attorney can satisfy her.
Leave that out,
Well,
and also the language on that is creepy.
it really is. Well, just leave it out. You don't need it. Get it out of there. What the hell are you doing? You're doing all the things, but is it foreboding? Are we
The thing is,
predicting-
let the court make that determination. Don't tell the court that.
Oh, I know. I agree with you 1000%.
And like, as no attorney can satisfy her, you can't make that determination. You could, oh God, I hate the language, because when I say you, lawyer,
Easy.
couldn't satisfy her, that
Easy.
doesn't mean that
Easy.
some
Nope.
other lawyer couldn't.
Ian.
It's the language he used. I'm not trying to make it sound creepy. He just made it creepy before I got here. It's not my fault.
So
I
Bankowitz
take
ends up
responsibility when it's me. This one is all him. I would totally claim credit if it was me, but oh my God.
So Bankowitz gets out. He gets relieved of duty, and the judge appoints another attorney, right? Well, here's the thing. Ms. Boone, who writes letters, wrote another letter on January 19th. I had not seen this until today. January 19th. Judge Michael S. Kranick? Yeah. R.E. Sarah Boone. So this is a new judge. And she emphasizes that finally a new judge.
You know how to piss off the new judge?
Allow me to introduce myself. A la Sarah Boone.
Yeah, you know how you piss off the new judge? It's like this. Also, I'll be right back.
Yep. It's strange how the Lord works, as I was in the process of trying to disqualify Wooten after being my judge for years, and me still incarcerated with nothing to show other than 7 different attorneys, not by choice, news clips of me walking in and out of the courtroom, and everything relative to my care permitted to be slathered on the global internet, and in which I have not seen myself. Well, okay. Good first impression. Solid. I felt he was the ticket holder to my overly hyped, illicitly distributed, misconstrued, quote, criminal case. And great reason I am still here. Again, ongoing 4 years and 7 attorneys later.
By the way,
Parenthetical,
Mrs. Runkle is the best.
Oh my God, what is that?
That is a bubble tea.
Oh, yeah.
She knows I've been having a sore throat, so she was like, I was out and about. I brought you a bubble tea. So
Way to go, Mrs.
She is
Runkle.
the best.
Ongoing 4 years and 7 attorneys later. Again, parenthetical, not by choice. See my letter dated June 29th of 2023 on the clerk's website. Maybe don't point the new judge back to your old letters. While still waiting to properly elucidate the court, I hate
That's not the
using
right word.
words. It's not the right word, but it's a big one, and it's like, why?
If you're going to use a big word, it better be the right big word and not just a big word.
Elucidate the court, public and world, and after whatever the dysfunction was in the attendance part of my most recent PTC/status hearing, which I am trying to ensure my automatic attendance futuristically. Please see my draft motion included. I am still trying to have my attorney submit on my behalf. I wanted to bring to your judicial attention.
Can I translate the draft motion included?
Please do.
It means she wrote up some crazy bullshit. She said to the lawyer, I want you to tender this to the court. The lawyer looked at it and went,
no,
I cannot, because what the fuck is this? And there are ethical obligations where you can't serve up a turd to the court. And I think that's what she wanted. Like, here's a turd, please file. And he's like, can't file the turd. And
Well,
she's like, well, now I'm going to tell the court on you. Like, I'm going to tell the judge on you.
we're gonna get there. We'll get there. I wanted to bring to your judicial attention the following information so you and the world are aware. It is not I who am ever, quote, delaying trial, end quote, as Wooten inappropriately accused me of doing in a past hearing, especially now you have mandated a trial date to be had in May with no further continuances. Well, no further continuances until like next week, leaving less than 4 months to put together and complete what should and could have been done already. What happened in all the 4 years prior? Please see all my correspondence online. Or don't.
If I was her, I would not be asking the court to see all the correspondence online. I'd probably be saying, please forget that exists.
To date, Winston E. Hobson has been my court-appointed attorney for 133 days and counting. To date, Mr. Hobson has only met with me one time for a total of 3 hours on November 7th of 2023. So we are already throwing the new lawyer under the bus.
Yeah. And if you're the next lawyer in line, you're looking at this and you're going,
huh,
F this.
To date,
now, should we say throwing under the bus or throwing into the suitcase?
Well, suitcase is probably more appropriate. To date, no phone calls have been received by Mr. Hobson as his phone does not work properly for further immediate, much-needed communication to be made between client and attorney.
I.e., he's sending her like 62 calls a day directly to voicemail, and she's filling up his voicemail in the first like 10.
You know what sucks about this? Like a lot, like this trial. There's a victim here. Like there's an actual, like there's a victim. There's someone who was trapped in said suitcase, whose family and people are sitting there going, "We need this trial. Can this be done? Can we get to a disposition and a resolution?" There's two sides. There's the person who thinks they're going to go free, and the person who thinks that they need that justice to happen. All of this is preventing that from occurring.
Mm-hmm.
To date, I have mailed 5 letters to Mr. Hobson trying to communicate my urgent need to speak to him. To date, I have sent 1 letter to the investigator in my case to contact Hobson to contact me and see if he can assist in correcting the phone problem.
You know how you really make your lawyer happy is start calling everyone else to complain about your lawyer not getting in touch with you. Yeah.
Mm-hmm. Also to inquire when anyone is coming.
So somebody in the chat mentioned something here, and I'm just like, here's her general approach to life. And so if you're dating this person, you've got to be aware, at least tangentially, of this kind of thing. And then she says, you know what? Let's play a game. Climb into a suitcase for me.
God. Like how?
This is one of those ones where I'm just like, can the defense just argue that it was a suicide?
No, it
doesn't work that way. I know, but it's like,
this is pretty terrible. And the prosecution has the videos. They have the phone, the videos, the phone, everything. And the videos of the taunting.
Men, life advice out there. You will meet somebody out there who might be very attractive or not, but might be a lot of fun. But you know they're crazy. And I say men because it applies to women too, but it seems to apply differently.
I don't know. I've seen some bad shit.
Yeah. Oh, I mean, I've seen really bad shit with women, but not typically the like I'm staying with her because she's attractive, which guys sometimes get into.
Hey, let me give you this one. I'm staying with him because I can fix him.
Yeah.
Yeah.
It never ends well.
Yeah.
This is like getting into a plane that you see like fire coming out of and it's headed toward a mountain, and you get into it and it's like, I can fix this.
Yep.
Unless you're real sure, you're ending up in the mountain.
Yep.
And not like the surface of the mountain. You're like mining for silver in that mountain.
Mm-hmm. Like,
and probably just
they
mostly
love
mining
me.
for
They
fire.
love me so much. It's just their love. It's very unique. It's very unique to them. It's their way of loving me. It's only you wouldn't understand. Okay, that's one example. Other one is, but you don't get it. She or he is better. I can fix them. You can't, like, that's, you just be wary of yourself.
And-
be safe in who you're dating and what you're dating, and date for the right reason, the right person. Please, God,
The
please do.
horrible thing is that everybody who comes in and they're like, our love is special and unique, when they're telling this to their criminal defense lawyer or their family lawyer, either of those lawyers will be like, and by unique, you mean I've seen this pattern hundreds of times.
Yeah.
Yeah.
I'll tell you right now, Mischief Manager ain't gonna fix me. Nope. The juvenile tendencies in my life, in my existence, my desire to use Nerf guns as a showing of love, that is not going to be fixed. You cannot fix that out of me.
Oh,
So-
yeah. Mrs. Runkle is like, I'm aware of your quirks. I remember at one point I was like, thank you so much for putting up with me doing this crazy thing. She's like, I knew what I was buying. When we got married, like, I knew this was part of the package. Like, maybe not this specific thing, but like in general. And I was like, fair.
Side note, there had to be a little bit of you when Mrs. Runkle and I were going back and forth in Vegas, like just chatting. It was like, this isn't fair. They're teaming up on me. It's like, no, like, we get you, you son of a bitch. It was so funny. Oh God, that was one of I loved hanging out with that was one of the
I'm
best
so glad you got to
weekends
meet
and the
Mrs.
best
Runkle
weeks. That was
because
so much
yeah.
fun. It was
Yeah,
so much fun.
Rob got to meet Mrs. Runkle, has confirmed she actually does exist and is
She's
as
amazing.
advertised.
She's a badass. Like, she's awesome, amazing. Love her. Everything about her. It was fucking awesome. It was like, oh no, that's you. I get it now. I understand. You've got him just fine. We're good.
Yep.
It was great. One of my favorite things in the world.
Somebody says, is she really taller?
Oh yeah, she's
substantially
as tall as I am. About as tall as I am. Maybe
I think
she
a bit
might
taller.
be an inch taller.
Mm-hmm.
What is she? 6'1"?
She's tall.
Yeah. No, she's tall. It's really cute. It's one of the cutest things in the world. Honestly, it was so much fun. It was one of my favorite things. Okay, so continuing on. To date, I feel I am not being included or heard or cared about in my case again. From the continued miscommunication again with Mr. Hobson and time-consuming undiscussed entries are being made on my behalf. The continuance I did not know about, the waiver of appearance I did not know about, along with other documents, and I am never sent copies of anything filed, so I know. I keep trying to tell him about, with no response, furthering the already massive dysfunction in my 4-year case. I was hoping in the PTC status hearing on Tuesday, January 16th of 2024, I could at least play, quote, catch up in the courtroom, end quote, for 5 minutes. So many of my attorneys have done prior, including Mr. Hobson in the one court date I've had for a continuance of a continuance, just October 30th, 2023, to express and emphasize the need for him to communicate and schedule a second very overdue meeting. I still have not even heard from Mr. Hobson about, what is that word? Any missed PTC? I don't know. Status
About
hearing.
our
What is
missed
this?
PTC slash status hearing.
Our missed PTC slash status hearing. What's the status to date? 1 out of 133 days and counting, attorney and his client have met. To date, 3 out of now 3,192 hours. That's some math. Because that's like the hours you're sleeping too, right? Presumably, attorney and client have discussed partial general case information. To date, I still have not seen my discovery. This part I kind of have a problem with. If that's true, I kind of have an issue with that. Like, but again, I wonder if that's true.
I don't know how much I can trust her. And the other thing is, I mean, the lawyer before the discovery in this file is probably going to be extensive. And the thing that happens when you're a new lawyer coming on the file is, of course, he's going to ask for a continuance because he's going to need one. And then he's going to go through all of the material, because the last thing you want to do is sit down with your client and say, let's go through the discovery, and then you have no clue what's in it. Because your client at that point expects you to know it back and forth and be able to explain it, unless it's like a meeting where somebody's coming into your office and dropping it in your lap and you're reading through it. Yeah, of course they're going to take a while.
This is a great question. Apple Silver. Robin Ian, how does privilege work with letters like this? It doesn't fucking exist. You are doing the very definition.
Oh, she's blowing holes in privilege.
Just voluntarily and knowingly knowing that the world sees, because she knows the world sees these letters. She has commented in previous letters about how people have read the letters. She knows they're public. And she writes it. Like, writing that is the definition of a knowing waiver. Like, the very definition of it. Julia 543, Robin Ian, I gave you a great intro to Moo's GoFundMe. Dr. Moo has a GoFundMe. She's needing some help. Y'all, thank you for sharing and letting the mod share. Will you please mention it, please? If half the people here donated money, it would be incredible. Dr. Moo, who is a wonderful person who follows both Ian and myself, a wonderful, wonderful participant in the chat, is in need for some help. The mods are posting her link to her GoFundMe. Please check it out. Please. Don't give if you can't, but if you can, it is much appreciated.
If you can give, it's appreciated, but, you know, economic times are tough, especially if you're in Canada, where Trudeau is doing his best to, So,
continuing on with the letter, Your Honor, when is the next status hearing, please? Especially since we were not at the last PTC status hearing, and especially since I am trying to communicate with my attorney in more than one way to fully maximize and utilize the minute amount of time allotted before trial. My fair, appropriate, and lawful trial, ? Oh my. I am still wondering why, though. I've had to wait 4 years.
Her lawful law trial?
For something to finally happen on/in my case. Ask Judge Wooten. I wonder also, was I the oldest case on his docket? ? Either way, I'm still here, waiting patiently and very excited to get this highly anticipated, show, on the road. Well, maybe you don't use that language. I await your overdue and very needed judicial direction, supervision, and intervention. Oh, I love when they say the judge is overdue. Thank you in advance, Judge Kranick. Welcome. Sincerely, Sarah Boone. Oh, and here's the attached motion. I do appreciate that she actually styled it correctly, but she put draft in the margins. Very nicely drawn. In the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida. Florida versus Sarah Boone. Motion to be included in and allowed admittance to all defendants' pretrial conferences and hearings. Comes now defendant Sarah Boone by and through her undersigned attorney. Well, that's a problem because the attorney didn't file it. Winston Hobson respectfully requests permittance to attend all of my pretrial conferences and hearings ongoing until the conclusion of my criminal case.
I bet the next lawyer is going to love that.
Per Florida Rule of Civil Procedure 3.22001, the following is stated to lawfully allow my inclusion, particular participation, and requested admittance. 1, the trial court may hold one or more pretrial conferences to consider such matters as will promote a fair and expeditious trial. The defendant must be present at any pretrial conference unless the defendant's presence is waived in writing or on the record by the defendant or by the defendant's counsel with the defendant's consent. In support, the defendant alleges as follows: these pretrial conferences are for my personal individual criminal case. If professional YouTubers, news channels, oh wow, call out. Thank you, Sarah. I'm not a professional YouTuber. I'm actually a professional lawyer. If professional YouTubers, news channels, court TV, etc., are given permission and allowed entry to the courtroom for viewing, and the judge also is allowing the conferences to be streamed via live with all the court minutes uploaded to the internet and world, I, the defendant, should be included foremost. I don't disagree. She's allowed to be there.
I actually think that is a reasonable argument.
Yeah. Yeah, she's allowed to be there. Period.
Like, literally, you're letting the entire world watch this except me? Come on.
I can be there. I agree 100%. I may not have regular, consistent updates or communication with my court-appointed attorney, and by attending all my status hearings, I will know current status, important dates, casework being completed, changes in...
Uh-oh, Rob's dying.
Parties, timeframes, expectations, and all pertinent information. I, the defendant, have a right to know. Agreed. I agreed.
Yep.
Want and need to, regardless, regarding my case. All information is important, relative, and necessary to me. 100%. You know what, Sarah? I agree. 100%. Yep, you're right.
The problem is that often clients like this make themselves impossible to deal with. And then once they're impossible to deal with, they complain that their lawyers struggle to deal with them. So it's like, I don't know, but yeah.
3, I'm not consistently included in the certificates of service and sent copies of any documents being filed in court regarding my case as requested numerous times by the defendant in writing and verbally in the courtroom, neither by the judge, the court, or my attorney. Now that's a rule thing. You're not included on the certificate of service because your counsel is appointed, and now they should be sharing stuff with you, but that sharing doesn't happen contemporaneously. It's not immediate. It takes a minute. So you're not going to get real-time updates because the attorney has a lot of shit going on.
And I mean, I've had clients who get really upset because they're like, hey, you've had this, document. When were you going to share it with me? And I'm like, when it actually became worth
relevant
looking at.
And that's another thing is lawyers are tasked with and given a great deal of, so in trial and in leading up to trial, I have the right and authority to dictate how discovery is conducted. That's my right as a lawyer. Now I consult with my client. I don't have to, but I do. That's my practice, but I don't have to. So there are things that every client is allowed to have, but there are certain things where you as a lawyer don't have to advise your client of every single thing in the lead up to a trial.
Yeah.
Like example, if someone calls my office, I don't have to call my client immediately and say, this person called my office. It's impossible.
I mean, as an example, I had a client who got really pissed off because I told him at one point, I was like, hey, we got some additional, I called him and said, hey, we got some additional disclosure. It's not interesting. I just wanted you to know it came in, but there's literally nothing in it we care about. And he's like, so when are you coming in to, because he was in custody, when are you coming in to review it with me? And I'm like, never. All it was is So in Canada, we've got these things, McNeil reports. For the officers, it's have they had any disciplinary history? The prosecution's required to tell us that. And I got a package back that said no for like 8 different officers. There's no disciplinary history. And so I told the client that, like, hey, there's no disciplinary history for any of our officers. So that's all they said. There was no reason to go into the prison to sit down and be like, no disciplinary history for Officer Bob, none for Officer Frank. You know, so, but the clients get upset about that. There's good reasons sometimes to just not go over that. And I'd have shown it to the client just fine, like on the next trip. So,
Yeah.
like the next time there was something else to do.
Yep. Let me see. 3. So by attending my pretrial conferences, I will know what documents have been filed, need to be, and will be for and in my case. See, that part that's getting into the lawyer's provenance. The lawyer is the one that, like, they advise you, you get to dictate certain things, but they get to do the things. Another way I can know what is going on in my case and being worked on. 4, incomplete overall support. It is my right by law as an individual, defendant, and inmate to be included in any and all developments made in my case. Well, you don't get to know, for example, you don't get to know if the prosecutor's office fired one of their deputies. You don't get to know if, a subpoena was issued to a random non-party. Like there are things you don't automatically get to know. It is also my right to finally achieve success in any and every aspect possible in my case. Well, by attending and being included in my pretrial conferences and hearings, said success can and will be accomplished fairly, faster, properly. Okay. Wherefore, the defendant, Sarah Boone, respectfully asks this honorable court to grant my motion to be included going forward to all defendants' pretrial conferences and hearings. You know what, Sarah Boone? Grant it. You're allowed to be included.
Depends how disruptive she's going to be.
I certify that an original of this document has been filed via U.S. mail with the clerk of the court, and that a copy of this document will be filed in the Florida e-portal to state attorney and all attorneys or other parties of court record on this 19th day of January 2024, and she signs it. So inmate number, and there's the envelope scanned for good measure. Well, that was the road to date. But wait, there's more.
Yay.
Really?
Mm-hmm.
Filed February 1st of 2024. 7:20 p.m. God, this lawyer busted.
I'm guessing that like they had a conversation.
I'm trying to put my.
She was calling him all through dinner, and finally he finished up his dinner, looked at his like 37 voicemails, was like, play, and got to like 18, and then just sent this in. That's exactly how that went.
Motion to withdraw, motion for reassignment of court appointed case. Comes now Winston E. Hobson, Esquire, the undersigned court appointed attorney, and files this motion for withdrawal and reassignment and states. 1. Counsel was duly appointed and filed his notice of appearance and demand for discovery. The accused is charged above solid cause with second-degree murder in violation of Florida Statute 782.042. 2. Counsel has met with the accused at the jail and in video visits and has continued the work begun by prior attorneys in this matter and has also consulted with experts to appropriately position the case in the best interest of the accused, given the facts and the allegations in the accusations. 3, irreconcilable differences, including but not limited to ethical considerations. That's how you write it, folks.
Yep, you leave it vague. Because I know a lot of people out there are saying ethical considerations means she's a lying liar who
You don't know.
of lies. Maybe. Or maybe it's just that you discovered that, like, the girl you hooked up with on Tinder is Sarah Boone's cousin. Boom, you've got an ethical issue. There's all sorts of potential ethical issues that could come up, and many of them wouldn't be Sarah Boone's fault.
Yep. So, ethical
Incidentally, if that is who you're hooking up with on Tinder, maybe reconsider.
Reconsider it.
Or at least use caution. I don't know. Maybe Sarah Boone's cousin maybe she's perfectly fine. I don't know.
I don't know. So, including but not limited to ethical considerations have arisen in this case between the defendant and counsel, and it is in the best interest of the defendant that counsel be allowed to withdraw and the case reassigned to other counsel in his stead. That is how you write that, because anything else you have to say, you can say it privately in chambers, not for the public to see.
If you need me to file more, I can file more under seal.
Yeah.
Like,
just indication of at what stage he was when he wrote this. Winston Hobson, which is not his, just there's a lot about this filed in the evening at the time of day it was filed, with this very brief, like the alignment not being right. A lot of this is suggesting to me that this was, as Ian described, this fucking case. Like, I can't do it. I can't do it. So the question arises now, and
criminal
the
law,
question
folks,
was being postulated on Twitter last night was, when is enough enough? You have the right to counsel, but at what point in time can you forfeit that right?
If you start like effing around with this to frustrate the process, then yep.
Well, and what's interesting is that the judge in the last hearing on the withdrawal motion, the judge was very clear when the judge was admonishing Ms. Boone. You have the right to counsel, but it's an absolute right, but you can waive that. Like that can be forfeited by your own conduct. It takes a lot to get there. Example, Charles Manson. Charles Manson is assumed, presumed, and suggestions are that during a break-in trial, someone from the Manson family had something to do with the disappearance of his attorney, who later ended up being found at the bottom of what was the cliff? He fell off randomly.
Yeah,
hiking?
as one does.
As one does. After Charles Manson gave suggestions of maladies about to befall him. But a new court-appointed counsel was brought in, and that court-appointed counsel continued representing. So that right is pretty significant. Like, you can't just cast it aside.
And
so the
yet,
standard is, you're close. We're close. We are very close. Very close.
Yeah, I mean, there's a real possibility that this gets that she ends up. I mean, she might end up going to all of her status conferences
as a pro se defendant.
Yep.
Good point. Hang on. Good point. Sarah, sorry, I'm not fully educated on this. But why aren't Boone's lawyers making contact with her, even if they just say they have other cases? Here's the thing. Most cases in the lead up to a trial, and when you're doing all this other stuff, right? There's either nothing happening, Literally nothing happening for a long period of time.
Mm-hmm.
And then all of a sudden there's a lot at once. Like you get a discovery dump and you go through it, you filter through it, you share it with the client, you say, set up a meeting. But that's like 3 months of no contact. And then I get a discovery dump and then I set up a meeting.
There's a lot of times you just don't need to talk to people.
Nothing happening. There's nothing happening. There's nothing I can do. This is set for trial. The trial date's there. The deadlines are there. Everything is set. There's nothing happening in your case.
Yep. And
Even
I've had clients where it's like, I don't need you to testify. You don't want to testify. I've got your signature on you're not testifying. The next time I'm going to see you is trial day.
Yeah.
Make sure you're there.
Because I am setting up witnesses. I am doing all this other stuff. This is stuff I have to do.
Yep. And if the next day is trial day, you don't have to be prepped, accused. So, if they're not testifying, so it's like, cool. You're actually the last person I need to talk to between now and then.
Yeah.
It's different if they are testifying, then you're going to want to meet them ahead of time and all of that fun stuff.
So your job is to keep them informed in a reasonable, timely fashion of the things they need to be informed of. They don't have to be informed of every letter, of every email. It's what they have to see in order to adequately prepare for trial. Sarah Boone has made her, everyone knows what she is going to say.
Mm-hmm.
Every prior lawyer, everyone knows what she's going to say. She doesn't have to repeat
it's going to be crazy
every
town.
2 minutes. Yeah. So that's the problem. So you can forfeit the right to counsel, but it has to be intelligently and knowingly made. And we're close. There is a case, and there's a possibility that the judge will say, you had the right to counsel. You forfeited that right. You willingly and knowingly waived that right by your conduct. We're not there yet, but we're close.
So it'll be fun.
If I'm on that panel for appointment, I'm going, please not me, please not me, please not me, please not me, please not me.
Yeah.
Benjamin Gray,
Hey.
just listening to trials while building cabinets. Love it. Thank you. Awesome. Judy, got this hearing EDB. Read Becky Boo Boo's emails was life. I have to set up a separate stream for that. Tommy Jones. Hi, Rob. Happy to have FNF. Miss seeing you more. I'm glad to be back. I have a lot going on. January and February are big months for attorneys. Like in my practice, it's really big. Raspberry, thanks for being a member. Lindsay, still waiting on the new puppy swoop of Leo Zoomies and some other adorableness. Did you see the most recent photo? I'm going to end on a happy
I saw
note.
a photo. I don't know if it's the most recent.
Your
I
client.
assume you're taking all the pictures of Leo.
Oh, all the photos. But your client is both lovable, wonderful, amazing.
Stop there.
Sleeping puppy. The awake parts are still a challenge. The awake parts are still tough.
All dogs are at their best while sleeping. I've been sick and Mrs. Runkle's often been at work. So Zora just comes up and she's like, I would like some, some snuggle time, and I'm going to let you sleep, but I'm going to sleep. And so she'll roll up against, it's like, aw.
Yeah. So there's Leo sleeping.
I noticed that he seems to be folded into some sort of pretzel.
That's his move, not mine, bud. It's his move. And then here's the other one, which was like, this one is just.
Oh, that's like future imposing Leo.
I know this fucking dog. He's like, he's all proper, and the big paws. He's like, I'm gonna be a big boy.
I'm gonna be a big boy, and I'm gonna be imposing when somebody comes over who's not supposed to be here.
Which is exactly. Mm-hmm.
Yep.
It's so hard to be mad at him. It is so hard.
Whoever pissed off the judge decided or appointing.
Draw straws. Yeah, probably. Forensics 805. Rob, there is not a limit of public defenders you can have. There is. It's just very hard to exhaust it.
It's the
Yellow
limit,
pill.
it's the number of public defenders.
Kind of. Yellow pill 17. Could the judge file future letters under seal so she doesn't get the clout she clearly wants? Nope. She has the right to speak.
Yeah, and everything in court is presumptively open. Things can be sealed, but it can't be for the purpose of muzzling somebody.
Correct.
Like,
she has the right to talk.
I'm intentionally filing this under seal in order to suppress this individual's, First Amendment rights would be it would be a look for the court.
Yep, not really. John Common, can we do a poll on whether she is malingering? I will do that when we get to trial. We don't have enough evidence. We don't have enough evidence on that. We don't have experts on that. We will wait till trial.
Is
Tiffany,
she actually claiming a mental illness?
no, I don't think so. She battered wife syndrome. So that's the claim. Tiffany Sobranik, my new dating profile tagline, quote, I love packing suitcases, but never with you in it. Solid move. Solid move.
I mean,
Let
you're
me know how
ruling
that
out
works.
some fetishists out there.
I don't know. Let me know how that works.
I mean, you could try the
Marissa.
opposite on FetLife.
Oh God, Ian. Oh, okay. Marissa, you're still going. It's Saturday morning in Europe. Happy Saturday morning. Reading A. I'm screwing that one the hell up. Can you
Reading? I don't know.
reading? Could you please give Pixie more attention before end? I want to contact her directly. I'm going to contact her directly. I'm not gonna throw her out there. I have been in that position before. This is not a wellness check. Do not do wellness checks. Do not do that. Someone brought to my attention that there is a possibility that a friend of mine is in a problem situation. I am going to contact her directly, privately, and not on a live stream. Rosie, thanks for sharing moves. GoFundMe. It's so important. Please check it out. The mods are dropping in the chat here for years. Hey guys, thanks for demystifying the process. Thank you. That is the entire goal. Joshua, thanks again for another great FNF and have a wonderful weekend, everyone. Thank you, Joshua. And thank you to all the mods. Joshua is one of them. Thank you to the mods for being here. I'm sorry I put you guys through a lot. It's 4 hours. I apologize. Amy Griff, did he get Bandit and Mia's gifts? He's got gifts. I've got them. They're here, Amy. I've got them. Soccer ball included.
I should send Leo some gifts, like a training cord to chew. It'll be like an electrical cord
if you
coated in like beef tallow.
No, he's already fine. Do not do that. Don't do it. Pay your reading. Why not make a form letter send her each month with any new info or a statement of no new info having come in? Because that's going to follow with calls. That's the problem that you run into is that giving anything in that moment is going to be 15, 14, 30 calls, and the call is never going to be. There are clients that I have that you cannot get off the phone with. It's not possible. And I get that impression. It's difficult. He or she has to prepare for this person's trial. And you need time to do that. Katerina Ferreira just got here, had grandmother's 96th birthday dinner. Cheers. 96. Sadly, no one's celebrating my birthday with me tomorrow. I am. Happy birthday,
Happy
Katerina.
birthday.
Happy birthday.
Also, where Rob is, it's tomorrow now.
That's true. Happy birthday.
See, he's already celebrating.
Already
I'll
celebrating
celebrate
your birthday.
in 2 hours.
Happy birthday. Kristen, M96, I was going to make Mischief a suitcase for her bot. But would that just freak you out? Yes. Do not make her a suitcase. We do not need suggestive anything. So
Suggestive suitcases?
no suitcases. None. All right. Thank you guys for being here. Thank you, Ian, for joining along. For those of you, I apologize for not getting to Murdoch. We went in great depth on the Crumbley case.
Monday, we'll talk Murdoch.
I will be on with Ian on Monday. Ian will talk Murdoch. Murdoch is going to be interesting. Oh my God, we have so many rants. Becky.
Oh my God, Becky.
Oh my God, Becky. Oh my God, Becky. And it's not
look at her book.
Oh my God, Becky. Look at her book. Oh my God, Becky. Look at her book.
It's just so plagiarized.
You know what? I need there needs to be a shirt. Oh my God, Becky. Look at her book. And then on the back, just it's just so quote or plagiarized. There's a thing called literary license. It doesn't mean lie. But we'll talk about that. Adrian Angevine, Rob, how fast can an attorney pull their name from the public defender's list? Just hypothetically. Coverage. Love you guys. I don't know. We're going to find out. It's going to be a race. All right. Thank you guys for being here. Really appreciate it. Thank you. Happy Friday and a wonderful weekend to all of you. Ian Runkle, you get fucking better. You rest. To all of you.
But I have more mocking of Janet to do.
You know what? The mocking brings you strength. So
it does.
It does. It's like your rehabilitative. I don't know how you do it, but it just does. Anyways, cheers to all of you. Have a wonderful weekend. Go make something. Go do something. Be happy. Make something. You'll feel better. And I'll catch you guys on Monday on Ian's channel, Runkle the Bailey. Go check him out. Please go check out Recovery Addict for live trial coverage. And I will catch you guys on the next side. Bye.